next week.
My lord, may I have my lord's leave to mention a matter? My lord, what has happened, my lord? This plaint has been admitted by your lordship. Now, what has happened, my lord? My claim is around 10 lakhs 54,000. And I have paid a court fee of rupees 25 lakhs 500.
25 lakh.
25,500. I'm sorry, my lord. Now, what has happened, my lord? The department has found that there is a word, valued at over rupees, for which the stamp reporter could not assess the court fee. My lord, what the department has said that mention it before your lordship, so that I can delete the word at over, for because of which they could not assess the court fee, my lord.
Okay, Monday kar do, to be mentioned.
I'm grateful to your lordship.
Lordship, I appear for the plaintiff, Lordship, plaintiff petition.
This court find that this is not the commercial dispute. The plaintiff is returned with the liberty to file a press before the appeal.
My application under order 38. It was served upon your lordship had directed to serve. We have served upon the other side. Service your lordship had directed by an order for deposit of security. Now, if your lordship, my lord, comes straightway, my lord, to the order, which is at page, my lord, 209 of the second volume. And then, my lord, your lordship takes, this was the first order.
Page?
My lord, page 211.
Yes.
My lord, your lordship comes straightway, my lord, to the, there are few things, my lord, paragraphs which I need to show your lordship, my lord, because of the order that I am praying for and the conduct of the defendant. Your lordship, my lord, kindly sees, your lordship had barred them from filing their affidavit in opposition. My lord, thereafter, my lord, this application was heard. Your lordship, my lord, kindly takes up page 209 once. That was the reason why I had come to page 209.
Yes.
The second paragraph, the matter was listed yesterday on 12th August and the learned counsel appearing for the defendant prays for a day's time to appraise this court whether the defendant has complied with the interim order passed by this court, and accordingly the case was adjourned. Today, when the matter is taken up for hearing, another advocate appeared for the defendant is questioning this court how the defendant can produce document to show that the interim order has been complied with. In spite of opportunity provided the defendant fails to file affidavit in opposition. Accordingly, opportunity to file affidavit in opposition is closed. And thereafter, your lordship proceeded, my lord, to pass the judgment, my lord, in my application for attachment before judgment. Your lordship, my lord, kindly comes to page 221.
They have not preferred an appeal against
No, they have not preferred an appeal. In fact, my lord, they have not furnished the security. I've got a report also from the master and from the registry, and they have said that the security has not been deposited. And thereafter, what they have done is, my lord, after taking out this application and after it was served upon them, I've checked the dates. My lord, the date of affirmation, they have taken out an application for extension of time to file their written statement way beyond 120 days, and also the application for extension was not filed prior to the service of this application. And thereafter, my lord, they had appeared before your lordship and we have taken directions for affidavits to file. Now, my lord, since...
So now what is this application?
Lordship,
this application?
my lord, this application, my lord, is for attachment of the properties, my lord, in view of the failure to file their, to furnish their security. My lord, it's an application, my lord, in the nature of, my lord, order 38, rule 6, my lord, of the Code of Civil Procedure, where it lays down my lord, that my lord, where it lays down, my lord, that if one fails to file a, my lord, first part is show cause to give security, or it says or. Since the first limb has been already been directions have already been given in this Order 38 Rule 5 application, so the first limb goes. So directly one comes to the second limb of Order 38 Rule 6, where, my lord, the properties can be attached in view of the failure to furnish security. My lord, they have not given any reasons also as to why they could not file. In their applications for extension of time to file written statement, that is also not given why they have not complied with. My lord, we have served upon them, they don't appear. But this has happened on an umpteenth occasion. My lord, I was, my lord, in fact, my lord, already there is an order of an injunction. My lord, there are the two properties, my lord.
Yes. So, as per the order data, again you sent. Serve the copy to the learned advocate.
I have already served, my lord.
Where is the affidavit? Hmm.
My lord, I would be praying, my lord, for the time being, my lord, F. But let him take symbolic possession, my lord, of the two properties which upon which there is an injunction already, my lord, passed by your lordship in the order dated, my lord, and an attachment to, for the reason to furnish security. My lord, page 221. Let the receiver go, take symbolic possession and make an inventory at least. My lord, and let us find out, my lord, whether the properties are at all there or not, or whether they have siphoned it off to third party.
Yeah.
For the time being, I don't want an attachment. At least for the time being, let a receiver be appointed, seeing the conduct of the respondent, my lord, to take symbolic possession and make an inventory.
Since offering for the plaintiff, none appears on behalf of the defendant. The plaintiff has filed the present application being GA3 of 2025, praying for attachment. The plaintiff has also filed affidavit. The matter was listed on 14th of February 2025. On the said date, plaintiff has filed an affidavit of service showing the service of notice upon the defendant. Plaintiff has filed the affidavit of service showing that notices of the present application were sent to the defendant.
And I'm filing my affidavit of service.
But it was written unserved with the endorsement left addressee. By an order dated 14th February 2025, this court directed the plaintiff to serve the notice by speed post as well as through email to the defendant as well as to the erstwhile advocate of the defendant. In compliance of the order passed by this court dated 14th of February 2025, give the affidavit service
Lordship.
2025, the plaintiff had sent notice to the defendant as well as the learned advocate. You have sent to the advocate also. What has happened?
Sent
to the defendant.
address as well as his office address at
To the defendant.
both of them.
To the defendant, and the same was duly received by the learned advocate on record of the defendant, but none appears on behalf of the defendant. The affidavit of service filed by the plaintiff be kept in the record. The grievance of the plaintiff in the present application is that by an order dated 20 September 2024, this court passed an order of injunction restraining the defendant from disposing / alienating / creating any third party interest with respect of a flat number Roman 5 dash Roman 1, comma, first floor, comma, Merlin Warden Lake View, comma, 104 Bidhan Nagar Road, Kolkata 700067, registered in the name of the defendant, comma, second being the Merlin Warden Lake View, comma, 104 Bidhan Nagar, comma, first floor, comma, block number 1, unit F and G, Kolkata 700067, and also two other immovable assets situated at P-499, Hemanto Mukherjee Sarani, Kolkata -70029. This court further directed the defendant to furnish the security to the extent of rupees 3, 37, 42, 633.27 with the registrar of this court within a period of 2 weeks from the date of receipt of the order. Counsel for the plaintiff submitted, in spite of the order passed by this court,
At page 224 is the report, man.
Counsel for the plaintiff submitted, in spite of the order passed by this court, the defendant has not deposited the said amount with the registrar of original side of this court, and accordingly, the department has submitted the report that no amount by way of any instrument has been received by the office. Police. When the plaintiff has filed the present application, notice was served, but the same was written unserved with the endorsement address left. Subsequently, in terms of the order passed by this court, the plaintiff has served the copy to the learned advocate on record of the defendant, which was duly served, but none appears on behalf of the defendant. Now the plaintiff submits that, in spite of the order passed by this court, the defendant failed to deposit the amount, and as such, at this stage, it would, and as such, a receiver is to be appointed.
In fact, my lord, the prayer for the receiver would be too harsh, perhaps at this extent, and my prayer is also too large. My lord, prayer A, perhaps, my lord, would be a better one, my lord. It needs to be attached, and the respondent be called for to attend on a specified date to take notice of the date to be fixed for settling of the terms of proclamation. But perhaps that is the first order which needs to be passed.
In order,
or your lordship can appoint a receiver, my lord, modulate the terms.
appointed, and as such, a receiver is to be appointed for taking symbolic possession of the property in question and for making inventory of the properties of the defendant. Consider the submission made by the counsel for the plaintiff. This court find that the interim order was passed by this court dated 20 September 2024 after hearing the counsel for the defendants. This court has specifically directed the defendant, specifically restrained the defendant for alienating the property and also directed to deposit the amount. The defendant has neither appeared before this court nor has complied with the order. Thus, this court is of the view a receiver can be at this stage, a receiver can be appointed only to ascertain with regard to the properties of the defendants. so that the receiver can make an inventory of the properties of the defendant and to file the report before this court for taking further steps in the matter. In view of the above, who will be? Yes, Mr. Alim. How many years you are having the practice?
This is my fourth year.
Fourth year. So and so appointed as receiver. As receiver. To take the symbolic possession of the properties of the defendant as mentioned above, and also to make inventory of the property of the defendants and to file the report before this court.
And also the bank accounts.
Before this court, full stop. This court find that the defendant is also maintaining the bank accounts where you mention the details of the
In
bank.
prayer E, my lord. Prayer F, my lord. Bank accounts, namely Federal Bank, Ultodanga branch, and HDFC Bank, Mumbai branch.
Mumbai branch, how it can be? Maintaining, but you not mention the account number.
But your lord, my lord, we have only got to know, my lord, there is a HDFC Bank at Mumbai branch. Document over there.
Let this property be
Very
taken.
good.
He will check. No, get it. Full stop. The remuneration of this receiver for the present
No,
is
let
fixed.
the Federal Bank maybe.
Where it is?
My lord, at prayer F, my lord. That Federal Bank, Ultodanga branch.
It is also found that the plaintiff is also defendant is also maintaining the bank account at Federal Bank, Ultadanga branch, and HDFC Bank, Mumbai branch. Which branch?
My lord, that is not known. My lord, later, my lord, when the calls for the respondent, we will.
Mumbai branch. Thus, the receiver is also full stop. This court find that with regard to the HDFC Bank Mumbai branch, the plaintiff has not given the proper details of the said branch, and as such, the receiver is directed to collect the information with regard to the status of the account and the available fund in the account maintained by the defendant in the Federal Bank, Ultadanga branch, Kolkata. Full stop. The remuneration of the receiver is fixed at rupees 40,000, and the receiver is directed to submit the report before this court within 3 weeks. It is in the Calcutta.
It's in Calcutta.
Within 3 weeks from date. Full stop. The receiver is given liberty if any resistance, if the receiver finds any resistance from the defendants, their man or agent, while making entry, by taking symbolic possession and making the inventory of the properties of the defendant, the receiver can make appropriate request before the concerned police officer police station, and if any request is received by the concerned police station from the receiver, the concerned police officer shall provide sufficient protection to the receiver for taking symbolic possession and making inventory of the property of the defendant in terms of the order passed by this court.
The
Full
receiver should also affix, my lord, a notice. My lord,
Full
receiver.
stop. The receiver and the branch manager or the competent authority of the Federal Bank Ultadanga branch is also directed to provide all assistance to the receiver for providing the details of the bank account of the defendant lying with the said bank with regard to the funds available in the said bank. Full stop. The receiver is also at liberty to paste the notice with regard to the symbolic possession of the property in question in the conspicuous place of the property in question of the defendant. Full stop. Let the matter appear on आज क्या तारीख है 27/3/1/2 let the matter appear on 25th of March 2025 for filing report by the receiver.
Brief.
Lord, I'm for the plaintiff, my lord. This is my application for summary judgment, my lord. But only thing, my lord, I've served them on 18th, but
Huh?
I've served them on 18th,
Ah,
but my lord, the track report is not available because the track report page shows that the consignment tracking system is currently under maintenance. I will
So-
kindly
so-
keep
so-
it on Tuesday.
Supreme for the plaintiff. Counsel for the plaintiff submit that though the copy of this application along with the enclosures have been sent to the defendants or defendant
Defendant.
to the
One
defendant, but he could not get the track report. Accordingly, he prays for adjournment. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 7th March. Next.
My lords, I appear for the plaintiff in this matter, Your Lordship. Your Lordship, in compliance with the last order, we have filed our affidavit in reply. This may be taken on record, Your Lordship. Your Lordship, may I bring your kind attention towards order dated August 30, 2024, Your Lordship, wherein Your Lordship has directed a defendant to deposit an amount of rupees 80 lakhs with the registrar original side. Your Lordship, the defendants have not yet complied with the said order, Your Lordship.
By which order?
August 30, 2024, Your Lordship.
30 August.
Yes, Your Lordship. At page 4 of the order, Your Lordship, in view of the above, the defendant is directed to furnish security deposit of an amount of rupees 80 lakh with the registrar original side of this court within 2 weeks from the date of receipt of the copy of
Yes.
this order. Your Lordship, they have not yet deposited the said amount with the registrar original side, Your Lordship. Your Lordship, earlier Mr. Somo Basu was appearing for the defendant. Your Lordship, he is not present today.
Who appear?
Mr. Somo Basu, Your Lordship, in the order dated January 21st, Your Lordship,
Against the defendant?
for the defendant, Your Lordship.
For the defendant?
Yes, Your Lordship.
So what you want now?
Your Lordship, we have also taken out an application for judgment upon admission, Your Lordship.
Hmm.
It is also listed today.
Hmm.
Your Lordship, I am being led by Mr. Ratul Das.
Hmm.
He is on his legs today, Your Lordship.
Hmm.
May I kindly pray before Your Lordship to extend the interim order, Your Lordship,
Hmm.
and keep this matter for hearing on the next day, Your Lordship.
Affidavit in reply
Yes, Your Lordship. To the
of
opposition.
J1.
Yes, Your Lordship.
So appearing for the plaintiff. None appears on behalf of the defendant. Plaintiff has filed the affidavit in reply. Let the same be kept with the record. What is the GA2?
Your Lordship, it is for judgment upon admission.
Have you served?
Yes, Your Lordship, the affidavit service, Your Lordship, it may be taken on record.
Full stop. The counsel for the plaintiff has also filed an application. The plaintiff has also filed an application being GA Com 2 of 2025, praying for judgment upon admission.
Yes, Your Lordship.
Full stop. The plaintiff has filed the affidavit of service showing that the copy of the application being GA Com 2 of 2024 along with 2025 along with its annexure have been duly served upon the defendant, but none appears on behalf of the defendant. Full stop. counsel affidavit in reply क्या बोला? Okay, ठीक है. Full stop. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 4th of April 2025 or until further order, whichever is earlier. Full stop. The defendant is directed to file affidavit in opposition in connection with GA Com 2 of 2025 within 2 weeks, reply if any there to be filed within a week thereafter. List the matter on 28th of March 2025.
Much obliged.
But I am for the petitioner, my lord. I am originally the defendant in the suit, my lord. This is an application under Order 9, Rule 13, my lord, for setting aside an ex parte decree, my lord, which was passed, my lord. And admittedly, the summons could not be served upon me. A paper advertisement was made. And afterwards, from a criminal proceeding, my lord, they have disclosed the decree from which we came to learn about the decree and filed the present application along with the Section 5 application. Though the Section 5 application may not be required, my lord, because the original decree was passed on, my lord, 27th of
You are
August.
appearing for defendant.
Yes, my lord.
You filed an application BA, GA2.
GA2 and 3.
What
One
is
is, my lord, Section 5 application.
GA2 is section 5.
Yes.
And
Lord,
GA3 is?
GA3 is for setting aside the ex parte decree, my lord.
Okay.
Now, my lord, the decree was, my
Have
lord,
you served? You are received.
it is appearing after, my lord, direction of affidavits were passed, my lord, on
File
6th
the
of January.
affidavits.
My lord, we have not been,
I filed the appearance position, me.
You are appearing for?
Plaintiff degree holder.
Both.
Both are.
my lord, the direction on the last occasion was on 6th January, my lord.
Have you not served the copy?
My lord, by 3 weeks, they are supposed to file the affidavit in opposition, which they have not filed.
Hmm.
And my lord, in this kind of matter, my lord, it is a matter of record, and I will show that the address on which they have might have attempted, my lord,
That
that was.
is the merit of the, if you will accept the affidavit or opposition or
No, I
not.
have not yet received it.
You have already received. Yesterday I have.
Yesterday I have
whom?
served. Just.
To whom you have served?
Yes, my lord.
কিসের কাকে দিয়েছে?
কালকে দিয়েছি বাড়ি।
এটা?
হ্যাঁ, এই তো দিয়েছি।
একবার দেখি। Oh, Ashish Kumar Sen ke diyeche. Lord, yesterday evening after I have left, my lord, might have been served, my lord.
Hmm.
Be that as it may, my lord, then your lordship may take up the matter because
So you will not file affidavit?
I have not gone through. আমাকে একটু একবার দেখাবেন আপনাদের কপিটা? What point they have taken, I don't know, my lord.
All points have been taken by them. Nothing has to be taken by me. They have given their own answer.
This is with regard to the GA5, condonation. What about the Order 9, Rule 13? Not filed.
Both the both.
You filed the affidavit in connection with GA2. What about the GA3?
3 is there
Filed.
also. Both have been.
দুটোই কপি সার্ভ করেছেন তো?
What?
Both taken the matter, my lord.
Item number? GA2 is appearing. Yeah, GA3 is not appearing.
My lord, before taking the matter, I submit validity a money degree. That the defendant be directed to secure the claim of the.
This is not an appeal, sir.
My lord,
This is not an appeal. Go file an execution case, then we'll see to that. This is not an appeal. This is Order 9, Rule 13.
also the section 5 is there, my lord.
Maybe, but this is an appeal.
I know Section 5, why I am saying Section 5 may not be required because the decree was passed on 27th of August.
GA3 is not on record.
Lord, then it appear after, my lord, 1 week, my lord, within that time, my lord, I will also file the reply. Or 10 days after, my lord. 10 days after.
So and so appearing for the plaintiff.
18 পরে বলুন।
So and so appearing for the defendant. Defendant had filed an application being GA Com 2 of 2024. Praying for condoning the delay for preferring an application under Order 9, Rule 13 of the Code of Civil Procedure for setting aside the ex parte decree. The defendant has also filed an application being GA3 of Com 2020 and GA Com 3 of 2024, praying for recalling of the setting aside the ex parte decree dated 27th of August 2024. Today, GA Com 3 of 2024 not in the list. The defendant and the plaintiff has filed affidavit in opposition in both applications after serving the copy to the learned counsel for the defendant. Let the same be kept with the record. The counsel for the defendant pressed for time to file affidavit in reply of both the oppositions. Let affidavit in reply be filed within 1 week.
Within 10 days, my lord. Within 10 days. 10 days, my lord.
Within 2 weeks. Within 2 weeks. List the matter. On 18th of March 2020.
My lord, instead of 18, or can it be on 9?
18. I will not be here up to 18, my lord.
Up to the 21st of March. 21st of March 2018 under the heading adjourn motion.
And my lord, both the matters should appear.
Yes, yes. The department is directed to place the record of GA 3 of 2024 on in the record of CS 238 of 2023 along with GA 2 of 2024. Yes, next.
It again.
That it's one of the LC matters.
Yes.
Your Lordship had passed on 31st January 2025, extended the earlier order to other bank accounts and had directed, my lord, kindly come to internal page 2. Directed us to serve the supplementary affidavit on the defendants. My lord, may I file the supplementary affidavit? I'm sorry, my lord, the affidavit of service showing, my lord, service of supplementary affidavit on all the defendants.
My lord,
And my lord,
I am appearing for defendant number 2, my lord. This is the letter from the bank, National Bank, Bangladesh. To the My lord, I have already sent the vokalatnama and competency on behalf of the bank, my lord. My lord, I am praying for 3 weeks' time. They will send it after completion of the procedure. My lord, this is the, yes, my lord, vokalatnama and competency.
On behalf of defendant number 2, National
Defendant
Bank.
number 2, my lord, National Bank, Bangladesh.
What about the one you are not appearing?
one, she is not appearing.
Al Amanha Islamic
Investment Bank.
You're not appearing.
No, my lord, I am only for defendant number 2, National Bank, Bangladesh.
Yes.
So, my lord, your lordship had already given directions for affidavits. My lord, now she is appearing. Kindly extends the time by 2 weeks, my lord, to file the affidavit. And my lord, interim order is expiring today. Kindly extend it.
So and so appearing for the plaintiff. Plaintiff has filed the affidavit of service showing that the supplementary affidavit is served upon the defendants. What's the good name, madam?
Sharmishta Das.
So and so appearing for the defendant number 2 and submits that the defendant number C has received the information written instruction from the defendant number 2 to appear in the matter on behalf of the defendant number 2. Accordingly, she submit that the defendant number 2 is at Bangladesh and she has sent the wakalatnama. And it takes 3 weeks time to file the wakalatnama, and accordingly and as such the counsel for the defendant number 2 prays for 3 weeks time to file wakalatnama on behalf of the defendant number 2. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and prays for extension of interim order. Considering the submission made by the counsel for the parties, the defendant number 2 is granted leave to file wakalatnama. Counsel for the defendant number 2 is granted leave to file wakalatnama within 3 weeks from date. Full stop. The interim order granted earlier is extended till 28th of March 2025 or until further order whichever is earlier. Release the matter on 25th of March 2020.
But in the meantime, since several banks have been injuncted by your lordship's order here in India, if they can indicate, defendant number 2 can indicate that if any amount at all is lying in those accounts.
Let first let the wakalatnama filed, then sit. That's why you not pass any direction on.
Obliged.
Item number 10, I am for the plaintiff, my lord.
Yes.
There are 3 actions, including one order 12 rule 6, wherein my lord,
I appear for the defendant, my lord.
Wherein my lord, despite
video is not getting on, my lord. I'm
wherein
trying to switch on the video, it's not happening, my lord.
My lord, item number my lord, GA number 2 is our application under order 12 rule 6, my lord, wherein my lord they have been given the chance to file affidavit because they were required to give security of the admitted amounts, my lord. Wherein my lord till date no affidavit has been filed. In the meantime, they had mentioned for extension, which had been refused, my lord. So, my lord, as of date, my lord, they have not filed any affidavit. This has gone one, my lord. But there are 2 other applications, my lord. Now, my lord, to restrain or bypass the effect of this application, they have filed one order 7 rule 11, which is, and my lord, there is already another application, that is our injunction application for since there is an admission on their part, so the injunction on the restraining the bank accounts to to operate the bank account.
May I summarize, my lord?
So you filed 2 applications. One is injunction,
yes.
Second is order 12 rule 6.
Yes.
Correct.
Yes.
And they filed the temporary application.
I have filed an application at a very short point, my lord.
They
Very
have
short
not
point,
filed
my lord.
affidavit.
Part of cause of action admittedly has arisen outside the jurisdiction of this honorable court, and no leave under clause 12 of the latest patent has been sought for. And this is apparent from the face of records, my lord. But I humbly beseech,
My
my lord, can this be fixed on Monday, my lord?
It is
I
such
want
an
to do it physically,
application.
my lord. These matters can, my lord, my demurrer has to be
My
heard
lord,
first,
their
my lord.
demurrer, my lord, is a ploy, if I am allowed to
No,
say.
no, no, no.
My lord, all the defendants are within.
No problem. I will take all the applications.
Yes, the demurrer has to be taken up first.
There will be no problem.
And my lord, we shouldn't embarrass your lordship by mentioning, my lord, preferably at the top, at the time of when the matter is being taken.
At the top in the month of May.
Preferably.
In the month of May.
I'm leaving it to your lordship. But both of us knows, my lord.
Anytime, my lord, anytime.
खाली G3 है लिस्ट में है
बाकी all the applications are in the list. Item 16, 10 and 30.
Item
10, 16 and 30. 16 is my demurrer application.
Yes. देखो सब अलग अलग करते हो आप लोग.
Club
क्यों होता है? 10, 16 and
30, my lord. Item number
and 30. Mine is 16, the demurrer application.
एक साथ अब मैं बोलता हूँ CS नाम लिखो जी then it will be difficult.
Yes.
लिस्ट भी छोटा हो जाएगा आप लोग का. Item number 10, 16 and 30.
30, my lord.
ठीक है. So and so appearing for the plaintiff, so and so appearing for the defendant. The plaintiff has filed an application. Your application number?
My lord, my application number is GA2 of 2025
and GA3 is your injunction application.
My lord, GA3 is my injunction of all of 2024.
No, GA3 and GA2 is yours.
Yes, my lord.
Yes, yes. And GA4 is mine, my lord. 4 is mine.
Plaintiff has filed an application, file 2.
That is the last of the
application being GA-COM3 of 2025 and GA2 of 2025 and GA3 of 2020 आएगा. Praying for judgment upon admission as well as injunction. The defendant has filed an application being GA-COM4 of 2025 for praying for
revocation of leave, for dismissal of
leave and dismissal of the suit.
No, there is no leave. There is no leave sought, therefore dismissal.
Dismissal of the suit.
Yes.
Dismissal of the suit.
GA4
on the ground that the plaintiff has not obtained leave under clause 12 of the latest patent as part cause of action arose outside the jurisdiction of this.
Yes.
Full stop. This court is of the view all the application is to be taken of pleadings completed.
My lord, pleadings, my lord, in order 12 rule 6, my lord, kindly close the chance, my lord. They have not, despite getting the opportunity, they have not filed and the court has not been
I was humbly beseeching, my lord, if my demurrer application can be heard, my lord. First,
all will
be taken.
Yes, my lord.
Deploy, my lord.
And
all
the
applications will be taken
all
together.
applications will be taken of a hearing together. Full stop.
Yes.
In view of the above, the parties are directed to exchange their affidavits within 3 weeks.
My lord, only one thing, my lord, Testamentary, my lord.
Within 3 weeks, fully stop. List the matter on 28th of March 2025 under the heading adjourn motion for hearing of all application. It is made clear that by the date fixed, if the parties fail to complete the pleadings, the applications will be taken of a hearing without the affidavits.
May a time be fixed.
I'm deeply obliged.
That's why if you want time, then I will go to the April. Time all my till 20th April, all my diary is packed.
But order 12 rule 6, kindly indicate that my lordship will take up with order 12 rule 6 first, because that
I recorded all application will be taken. First, I will take the demurrer application, your application, all I will done. I will dispose of simultaneously. No problem.
Order 12 rule 6, lordship was already hearing.
That's why I will take all application, because otherwise one by one, and then never the suit will proceed it.
Yes.
So that's why this court has taken all application will be taken.
Come on, obliged, deeply obliged.
Next.
Your Lordship, I appear for the defendant number 4. Your Lordship, as per directions on the last date, an amount of rupees 5,000 was to be deposited in before the State Legal Services Authority, West Bengal. We have done the same, Your Lordship, and we have also served a copy of the written statement to the plaintiff, Your Lordship.
Lordship may record compliance and direct it to go out of the list. Not, I think.
So, then discovery inspection.
Yes, Your Lordship, we can do that.
Sole defendant. All defendants file written statement.
No, my lord. Other defendants, my lord, my lord, we are,
They are not filed.
they have not filed, but we are trying to verify the status service upon them. my lord.
What about the other defendants? You are appearing for 4.
Only for defendant number 4, Your Lordship.
Other defendants no written statement, not obtained the report.
Lord, Lord, in fact, one of the defendants, Lord, had written to us, that they had some dispute about the papers they had received. They're saying some of them were not legible, Lord, so we are forwarding them the.
So appearing for the plaintiffs. So appearing for the defendant number 4. The counsel for the defendant number 4 has handed over a receipt dated 21st February 2025 issued by the Cashier State Legal Service Authority, showing that in terms of the order dated 18th February 2025, the defendant number 4 has paid the cost imposed by this court. Let the receipt dated 21st February be kept in the record. Full stop. Counsel for the plaintiff press for time to obtain report from the department to ascertain whether the other defendants have received writ of summons or whether they have entered appearance or filed written statement or not. In view of the submission made by the counsel for the plaintiff, the case is adjourned for 2 weeks. List the matter on 18th of March 2025.
Grateful, Your Lordship.
For filing report by the plaintiffs to ascertain whether writ of summons is served or whether written statement is filed or not.
Grateful, Your Lordship.
Obliged, Your Lordship.
Filed or not by the other defendants.
Item number 12 for the plaintiff.
You are for the plaintiff.
In this matter, my lord, plaintiff, my lord, in this matter, my lord had granted an interim order on 9th of December, and my lord has extended from time to time, lastly on 31st.
31st of
last month, January.
January.
Which has been extended till today.
Yes. Who is for the defendant?
Yes. Now, my lord, no, my lord, several times, my lord, we have served. My lord, as my lord, recorded from time to time. Even the last day's order, my lord, kindly see, of 31st January, my lord, recorded the fresh affidavit service has been filed. I was humbly praying that my lord can confirm the my lord interim order, because this is the 5th or 6th time my lord is extended.
What about the writ of summons? What about the writ of summons?
Sir, my lord, served. No, writ of summons. Writ of summons has not been served. Oh, acha. My lord, writ of summons has not been served.
My lord, the scrutiny is yet to be completed.
Okay.
Scrutiny, my lord, is yet to be completed. My lord, they are on it.
Not yet completed, because I want that if the writ of summons is served and they will come, it's okay. Otherwise, I will confirm this and
I leave it to you. I leave it to your lordship. I leave it to your lordship.
So for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submitted the interim order granted earlier going to expire today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 8th of April 2025 or until further order, whichever is earlier. In the meantime, the plaintiff is also directed to ascertain whether the writ of summons is served upon the defendant or not. Let the matter appear on 8th April. Yes.
My lord. Deep love.
Next.
Obliged.
The 13 and 14, my lord, arise out of the same suit.
13, 14?
Both. My lord, 13, my lord, is my interlocutory application praying for certain interim reliefs, in which there is a subsisting interim order. And my lord, my learned friends were directed to file an affidavit in opposition, which my lord, they have filed. We have received it, although out of time, we have received it on 21st. My lord, I need some more time, my lord, to file a reply to that. That's so far as that 13 is concerned. 14 is, my lord, I believe that the defendant number 2 in that suit, my lord, has taken out an application for deleting its name from the array of defendants in the suit. My lord, I would like to use an opposition to that, my lord. So therefore, my lord, lordship can pass a composite direction if subject.
May I comment, my lord, for defendant number 2? I am a bit surprised that my learned friend wants to file a reply, because, my lord,
in his entire plaint, there is no allegation against me, defendant number 2. There is no relief claimed against me. As I clarified last time, I am simply the vendor for defendant number 1. I have no contract with the plaintiff. Therefore, by a judicial order, he is trying to stop me, which my lord had clarified last time. I have got nothing to do with the dispute, which is about valuation. I absolutely nothing to do. So I don't know why I should be compelled to.
Okay, if they want to file a reply, then I will decide that. No problem.
My lord, may my affidavit in opposition to
Of the
This is my
affidavit in opposition in connection with
J1.
J1. You also filed affidavit? No.
Yes, my lord. I just handed it over.
So and so appearing for the plaintiff, so and so appearing for the defendant. Madam, you are appearing for the defendant number?
One.
1 and so and so appearing for the defendant number?
2.
What about the 3 and 4? Nobody is there.
No, my lord.
3 and 4, I don't know.
Full stop. The counsel for the defendant number 1 and 2 have filed their affidavit in opposition in connection with GA Comp 1 of 2024.
You filed an
After
opposition to
serving
our
a copy to the learned counsel for the plaintiff.
Can you give us a copy?
Full stop. Counsel for the plaintiff pressed for time to file affidavit in opposition.
A copy of
Let
the
affidavit in opposition filed within 2 weeks.
Well, it will be a
Acha, no.
reply in the first one.
To file affidavit in reply to the affidavit in opposition. Let affidavit in reply be filed within 1 week.
Whatever your lordship.
Within 1 week. Full stop. The defendant number 2 has filed an application being GA2.
That GA.
Yes, GA2. GA Com 2 of 2025. Praying for deletion of his name from the suit. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition file within
2 weeks.
2 weeks. Reply, if any, there to be filed within a week thereafter. List GA Com 1 of 2024 and GA Com 2 of 2024 for hearing on 2 weeks, 1 week, 2 weeks. On 24th of March 2025.
Lord, until my application under Order 1 Rule 10 is decided, I may be exempt from filing the written statement because that may not be necessary.
You are filing an application.
That is a risk you run.
That cannot be. Full stop. The counsel for the plaintiff submitted the interim order passed earlier is going to be expired on 4th of March 2025 and press for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order which is going to be expired on 4th of March 2025 is extended till 28th of March 2025 until further order, whichever is earlier.
Deeply appreciated.
Next. 13, 14 both, huh?
My application.
I appear for the claim.
This is an application which has been filed in a commercial suit. Well, the suit is based on, is a suit for eviction based on 106 notice and thereafter eviction. This was filed when Deepak Polymer was holding the field. So I have taken a point that as on that day of filing of the suit, you could not have filed a commercial suit before this honorable court because kindly takes the plaint once, my lord.
What has happened to the?
That's under consideration.
That is under consideration.
That's still under consideration.
Let it be decided.
Yes,
Let it be decided.
Yes.
So maybe
That-
file affidavits in
Yes,
the
ma'am.
You file
application.
affidavit.
Right.
So appearing for the plaintiff, so appearing for the defendant. GA1,
This is no GA5.
GA5. What is that? GA5 is for?
Formula dismissal of the suit.
Counsel for the defendant has filed an application being GA Com 5 of 2025 for dismissal of the suit. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition filed within 2 weeks. Reply, if any, there to be filed within a week thereafter. List the matter on 4th April 2025.
Well, let this be decided first before any other application.
Let it come if it is. I will.
But they have another application.
Huh?
No, my lord, that's coming on the 3rd of March.
I will not. Yeah, I will not hear under that.
Obliged.
I'm grateful, Lord.
Your Lordship, I'm appearing on the behalf
My
of
lord,
Commissioner. I'm being led by Mr. Rashid Datta, Your Lordship.
my lord, this is my application, my lord, for extension of time to file the counterclaim, my lord. Lordship, I had mentioned this matter and Lordship had allowed or granted leave to file it subject to, my lord, me taking out a formal application. The delay is of only 9 days, my lord, if it can be condoned, my lord, because the written statement has been filed in the department.
Yes.
Yes, we'll serve.
Written statement to the counterclaim.
Written statement to the
Additional
counterclaim.
When
filed
the
by the
original written statement was served, counterclaim was served upon you.
My lord, 9th of January 2025 is the date of service, my lord. Kindly comes to page 15 of Lordship's, my lord, this application, page 15.
9th of January.
9th of January, and the previous order of your Lordship, 16th of December, which is at page 12. My lord, kindly comes to page 12. The order starts. The relevant part is at page 14, my lord. The last two paragraphs. Page 14, my lord. By an order dated 18th November, court has accepted the written statement. Now, today, the counterclaim filed by the defendant is accepted by granting leave under 12A. Accordingly, time to file additional written statement to the counterclaim is extended for 3 weeks from the date of service of the amended copy of the written statement.
Yes.
Now, this service was done, my lord, by the letter at page 15, my lord, which I showed just now, 9th of January. And the 3-week period, my lord, expired on 30th of January.
Yes.
My lord, so there is...
When you affirm the written statement, file the written statement in the department.
My lord, kindly comes to page 16, my lord, 16 of the application. There is an endorsement. I had mentioned the matter and Lordship had granted me leave on 18th of February to file the additional written statement subject to acceptance by the court. It is only this application is a formal application for acceptance of the court. The delay is 9 days.
Yes. Yes, Mr. Sengupta.
9 days delay. Only one thing, Your Lordship, he has
This
given an
actual written statement, that's 120. I don't know.
It is well within that 120-day period, my lord.
I
So I am
think
sure
has
Mr.
passed a
Sengupta is not
judgment
going to...
also, because it's not mentioned, Your Lordship, in Order 8, Order 8 Rule 6A. It should be, Your Lordship, as it
8-1.
Your Lordship, in
8-1. Treated as 8-1.
only one thing, Your Lordship, the junior is insisting we paid cost. So at least, Your Lordship, 10,000 rupees we pays cost, 10,000 should be imposed on them.
My lord, no cost should be imposed. I did not resist his, my lord, prayer for, my lord, dispensation of pre-institution mediation. I considered that. Mr. Sengupta shouldn't insist for cost here.
He doesn't have any right of audience there. That's why he did not say.
Since appearing for the plaintiff, since appearing for the defendant. Defendant has filed the present application being GA-Com 6 of 2025, praying for acceptance of the additional written statement to the counterclaim. Counsel for the defendant submit that. By an order dated 16th of December 2024.
My lord, I am for the plaintiff, my lord, not defendant, because...
Now, persons appearing for the plaintiff, persons appearing for the defendant. No. Plaintiff has filed an application being GA-Com 6 of 2025, praying for acceptance of the written statement, additional written statement to the counterclaim. Counsel for the plaintiff submit that by an order dated 16 December 2024, this court has granted leave under section 12A of the Commercial Court Act to the defendant, and the written statement and the counterclaim filed by the defendant was accepted, and the plaintiff was granted leave to file additional written statement to the counterclaim. So, counsel for the plaintiff submit that the counterclaim was served upon the plaintiff. Counsel for the plaintiff submitted the counterclaim was served upon the plaintiff on 9th of January 2025. And the plaintiff has filed the written statement on 18th of February 2025. Counsel for the plaintiff submitted with the leave of this court. The written statement was filed in the department on the same day, subject to acceptance by this court. Counsel for the plaintiff submit that there is a delay, and though the plaintiff has filed the written statement within 120 days, but the plaintiff could not file the written statement within the prescribed period of 30 days, and as such, he prayed for acceptance of the written statement by condoning the delay. Counsel for the defendant raised objection and submit that the plaintiff has not shown any cause as to why the plaintiff has not filed the additional written statement to the counterclaim within the prescribed period of 30 days. Though the plaintiff has received the counterclaim on 9th of January 2025. Had the learned counsel for the respective parties perused the documents and the application filed by the plaintiff, this court find that though the plaintiff has not filed the additional written statement within the period of 30 days on receipt of the counterclaim, but has filed the written statement within the period of 120 days. Thus, this court is of the view one opportunity should be given to the plaintiff, subject to payment of cost of rupees 3,000 to the State Legal Service Authority within a week from date.
Very well.
The department is directed to accept the written statement, additional written statement, subject to scrutiny by the department. So, copy served.
Yes, Your Lordship. Right now, yes.
Yes, my lord. Copy we have given right.
As the pleadings have been completed, the parties are directed to complete the discovery and inspection of the documents within 3 weeks.
3 weeks.
Within 3 weeks. Affidavit of admission and denial of the document be filed within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 4th of April 2025 for framing of issues. On the date fixed, the plaintiff is directed to produce the copy of the receipt showing that the cost has been paid to the State Legal Service Authority.
My lord, is it lordship's pleasure to, my lord, indicate within what time the cost has to be paid?
Within a week. Within a week.
Grateful. We shall do that, my lord. Great.
Grateful.
Yes, next.
Mr. Ghosh was.
Well, this is a matter where Mr. Thakkar had argued. Well, this is with regard to the infringement of copyright in respect of 2 books. And we had completed our submissions. Mr. Ghosh had started.
Mr. Ghosh is on lake in court number 41. Your Lordship, can the fix it and Sama that day, subject to your Lordship's convenience.
Mr. Thakkar will come subsequently.
He is arguing now. Kindly keep it on some other day.
Okay, not today. Let it come on Monday. Time permit will take. Not today. Next.
Lordship, Mr. Thakkar was addressing your Lordship. And it was fixed on the last occasion Mr. Thakkar had mentioned, and specifically it's been fixed for today because he said it would be convenient for him now.
Yes.
Mr. Thakkar, that day he had appeared, we had mentioned the matter. Thakkar was there. He said he'll do the matter whenever it's taken up. I think he's not there.
Nobody is there.
Nobody is there, my lord.
No junior. Not today.
Good.
Which one that?
So this is with regards to the firm matter, my lord.
That one?
Yes, my lord. Fox and Mandal Authority. Well, let it be passed to. I'll try and see if he is available.
Pass over. But 11:30 other matters.
I know, I understand, my lord. Great.
Next.
My lord, I am appearing for defendant number 2.
Item 20. Your Lordship has called item 20, my lord.
Yes, 20.
Yes, my lord. I appear for the defendant number 1. My lord, your Lordship was hearing our Section 8 application. My lord, it's a suit filed by Mr. Rotlanko Banerjee. My lord, was addressing your Lordships on this. Now, my lord, we had shown to your Lordships, my lord, the plaint. And my lord, your Lordships will remember the termination agreement, my lord, which had the arbitration clause. And my lord, the entire cause of action, according to our contention, my lord, was covered by the arbitration agreement. But perhaps I'm told, I heard your Lordship saying 11:30, your Lordships have another fixed matter. So maybe we'll not be able to complete this.
Okay, not
your
today. Not today.
May I say something, my lord? may I
date
say
or time
something?
could be fixed.
No, just a second, Mr. Awasthi. But I don't know, but considering Mr. Chakraborty was very kind enough to say that there is no urgency as such right now, we'll not trouble your lordships with a fixed time. But Malad, if it can be any day except Monday, Malad. From Tuesday, if it runs on the list, Malad, we are fine. Monday, we have some Malad difficulty, Malad.
Item number 20. Census appearing for the plaintiff, census appearing from the defendant. Due to paucity of time, hearing could not be, the matter could not be heard. Let the matter appear on 4th March.
4th March.
I'm
so grateful.
Grateful,
I'm so
Malad.
grateful. I'm so grateful.
Next.
I appear for the.
I appear for the plaintiff lordship.
Yes.
For the respondent, my lord, I am on reply. My learned friend had made all the submissions regarding. So, my lord, if I may just refresh your lordship's memory as to what is exactly the point of contention here. My lord, our point of contention as a defendant is that New Life is a family mark. It is being used by many members of the family, and plaintiff does not have a title to New Life. And even I'm taking the best case scenario. Even if
Raichaudhary starts, before Mr. Raichaudhary starts, my lord, my interim order is expiring today, and I have an application for amendment. My lord, the writ of summons cannot be served because in the meantime they have changed the name. So it's a small application for amendment, my lord. If the prayers can be allowed for that amendment, my lord.
Hey, क्या?
I have no objection.
वो है? Can है? जी? What is the amendment? Only cost title?
Yes. Only cost title, my lord. The name of the plaintiff, the name of the defendant has now changed, but because the writ of summons cannot be served unless yes, my lord. Now they have changed the name to Apprive. But I have also prepared a short list of notes of arguments.
Yes,
my lord. But these are done. Let Mr. Raichaudhary.
Well, I hope the notes of arguments are restricted to whatever has been argued.
Yes. So, Mr. Raichaudhary, we will give a copy.
Another thing is that we have no objection to the amendment, only without prejudice to the rights and contention that we have the right to use New Life. That is without prejudice. That because they will say that the name has changed, therefore you accepted that there is no right for. Right
subject to the result of this list.
Subject to the result.
Subject to the result. Definitely.
Yes, Malad. So the main point of contention of the defendant, that is us, is that New Life is a mark that is being used by the family members since it is a mark originated and adopted by the grandfather, one Dr. Idris. My learned friend's case and his best case scenario is that the mark has been originated by our father, that is the directors of the defendant and the directors of the plaintiff, their father, Dr. Ilyas. And by some waiver, by some unwritten agreement, the mark has come to the plaintiff, which is a company. This is my learned friend's case. However, it is not the case that it has come to the plaintiff to the exclusion of the others. Because if your lordship recalls, my lord, there was a case filed in Delhi. In Delhi, there is no case made out that there was permitted use. There is no case made out that there was profit sharing. There is no case made out that there was royalty given, which is the case made out in Calcutta. Correct. On that. And in the Delhi suit, not in the plaint, but in the replication, that is the rejoinder, they have admitted that these family members are using New Life in some way or the other. Then what my learned friend said, that even we realize that it is the father, Dr. Ilyas, who has coined the word, as a result of which we use Dr. Ilyas's New Life. My lord, my only reply to that is, Dr. Ilyas is my father. I have the right to use my father's name. Now, if I choose to use my father's name over my grandfather's name, doesn't mean that my father becomes the adopter. Because throughout we have said it is the grandfather who is the adopter, and your lordship will kindly take page 317 of our GA. Page 317 of GA2. That's in volume 3. I just want to show an example because a similar situation has arisen amongst the family members itself. If your lordship kindly takes 317, that is in volume 3.
Yes.
Your lordship sees a chart there. Lordship will kindly take item number 6. Item number 6 is Mohammad Anna Siddiqui. That is my uncle, who is a brother of my father, whose father is Dr. Idris, who's the original. And kindly sees, he chooses to use his father's name, Dr. Idris Homeo Pharmacy. So, my lord, it's a question that doesn't show that Dr. Ilyas is the one who adopted. And even taking the best case scenario, if Dr. Ilyas adopted, it still gives me the right to use because he was my father. And others are also using it. My lord, now the next point which my learned friend made, and he referred to the report of the receiver. If your lordship recalls, receiver report. If your lordship recalls, to the receiver's report, and he relied on the receiver report of one Mr. Altamash Alam. He relied, if I'm not mistaken, on page 50. Receiver report type. Altamash Alam. Company. Yeah, it's a report dated August 31, 2024.
Varun Kotari.
It's a very short point, my lord. May I just hand over the report, if your lordship kindly? My lord, page 51 of the report.
Yes.
Yes, my lord.
54.
51, if your lordship takes.
Yes, that's...
My lord, 50, 51, 52. Yes, my lord. 51, if your lordship takes. My lord, this was pointed out to say that NL Care is new life. And why? Because it is mentioned out there, NL Care Private Limited, previous name, Dr. Ilyas's new life. And therefore, NL Care cannot mean anything else except new life. It cannot be new leaf, it cannot be no, etc., etc. My lord, may I hand over the Companies Act under section 12? My lord, under the Companies Act, I have to do this. If your lordship kindly takes the Companies Act section 12. And my lord, my new name, NL Care, is mentioned predominantly. That is the predominant feature. The leaf is completely different. NL is written in a different way. Care has got nothing to do with new life. Your lordship will kindly take section 12. My lord, section 12, 3D. Section 12, 3D.
Section 12,
3. D, where it says have its name printed on Hundies.
3D, yes.
My lord, lordship will kindly take the proviso.
Yes.
Provided that where a company has changed its name or names during the last 2 years, it shall print or affix or print, as the case may be, along with its name, the former name or name so changed during the last 2 years as required under clause A and C. So I have to do this under section 12. It is not that I am doing it to show that new life NL is new life and nothing else.
Yes. Yes.
My lord, and this name also that I changed, NL Care, I changed it voluntarily.
Yes.
So that there is no dispute amongst the family members. So therefore, this point, my lord, does not stand because section 12, I have to do it. My lord, with your lordship's leave, my lord, Mr. Bachawat.
Yes.
Mr. Bachawat, with your lordship.
Yes, yes.
I apologize not for being late. But
yes,
these are small little points to answer some points made by my learned friend, but let's get to the core of the issue. My learned friend has argued a lot of things. He showed a lot of judgments, but now let's look at the core of the issue. Your lordship will remember in our vacating application when I moved it, not the one major point which I made, and that's the core that's not been answered properly, which is what? Not it's a title dispute over here. My learned friend is filing on the basis of trademark claiming to be the owner. Now, Lord, I had raised three major questions which have not been answered. Lord, one is, Lord, please remember, his client is a company. So how did the company acquire this title? Because there are three parts to it. According to us and according to them, the mark was conceived either by Dr. Ilyas or by Idris. One of the two. Either way, it doesn't matter according to me. So, Lord, first question is, who conceived of it? I'll deal with that. Second question is, not assuming that they conceived and not it was their mark. Assuming, because according to us and according to the admitted position in Delhi, 20 people were using it, all family members. But not assuming for a second that they were owners. Question is, how does it hop to the company? So this is the second question. Third is, even if it's hop to the company, can the company then claim exclusive right over the mark when there were 20 people using it before the company started using? So these are all family members. But the facts seem to suggest that this is a family-owned mark, at least not New Life. Now, I had showed a judgment to do with family marks. Your lordship will remember it. I'm not placing it again. I'm not Sriram's case. And my learned friend tried to distinguish it when we show the judgment. He admits the proposition. He did not distinguish the proposition. He distinguished the case on the basis that in that case, there was an admission that it was a family-owned mark. Or rather, sorry, at the time of application for the mark, there was a statement made that it is common to the trade. Now, Lord, in this case also, Lord, your lordship has seen the Delhi suit. When I say there are 15 users, he admits it. And he says, no, you're wrong. It's not 15 users, but 20 users.
Yes.
So here also that admission is there. My learned friend has not distinguished that point of law. So now, my lord, let's look at, and the fourth part is, to get around this entire weakness, there are two very weak links to this case. In Delhi, the claim of conception is that of Idris. Here he says it is Ilyas. Now, then he has to show it comes from Ilyas to first ownership of Ilyas. Now, everyone else was in the company and there were people outside the company carrying on. So, Ilyas could not have in any case been the exclusive owner. Now, so to make up for this, he now makes a case in Calcutta, which was not there in Delhi, that Ilyas waived his right in favor of the company. Now, your lordship will remember I made an argument based on the Trademark Act that if you transfer a mark or you assign the mark, it cannot be done unless you apply to the registrar and it is advertised in the Trademark Journal. Now, my learned friend has not answered that section 42 part of the argument, but he relied on Gujarat bottling for two purposes: to show that, look, apart from statutory rights, in common law, I can do it and there need not be, then I don't need to follow anything. I'll show that's completely wrong. Completely wrong, that will bust his case. The other weak link was, he claims now that he sees that there are 20 other users, he comes up with another new case in Calcutta that, look, they are all my licensees, because he can't explain why are there 20 people all using it. They are all my licensees was his case. Now, to which I pointed, look, again a case which is made up as an afterthought, not there in Delhi. Not a single document, despite my challenge, not one document has been showed that there is a license with any of them. On the contrary, an affidavit of one of the uncles is on record. I had pointed out saying that it is not his mark. I have no license agreement with him.
Correct.
Not dealt with by my learned friend at all. At all. Lastly, not licensing. He says there's a profit sharing with them. Not one document to show that. Not one document to show that he has a licensing agreement with 20 people, that they are paying him royalty. Nothing. On the contrary, my lord, his books show, my lord, what he's collecting from sale of medicine. There is nothing in the books of the balance sheet and other things to show that he's collecting any royalty. That will always be a separate entry. Nothing.
Yes.
That's a different point. Just keep it here.
Yes.
But this is the sum and substance. I say that there is no title. I'll take your lordship a little deeper into that just now when I get into the law. Now, not realizing this, please now try and see the two. He's trying to sail on two boats. One leg on this boat, one leg on that boat. But they are both the boats are both floating in different directions. It's bound to fail. I'll tell your lordship why. But on the one hand, he relies on the judgment to say common law, not statutory right. Now, when he's caught out, in the affidavit, I showed it to your lordship. He says in the opposition, please see his opposition, page 10.
Opposition of?
GA2. And I had made this submission not dealt with. Page 10.
Yes.
But no doubt, he pushed his case very, very strongly. But please look at the inherent weakness. Now, about 9 lines down. Sentence beginning with while it is true. I showed this earlier. While it is true.
Yes.
While it is true that no family member could claim exclusivity over such trademark and name. So, that includes him. It is true and correct, both in fact and law, to say that such exclusivity can be and is claimed by the respondent. Why? As a consequence of having a registered trademark. So now, his case is based only on registered trademark. He says in law, common law, I don't have that right. Everyone has equal right. But now that I have got registration, I have the right to prevent everyone. This is his case. So, on the one hand, now his case hangs tenuously on a case of infringement, but his defense is that, look, Trademark Act doesn't apply to me.
Yes.
Trademark Act, which requires advertisement, if I assign, if I license, all that doesn't apply to me. So, he's sailing on two completely different boats, heading in opposite directions.
Yes.
And your lordship knows the fate of such a person with his feet on both, two boats. What happens? Now, to get to the legal point. Factually, if I can just very quickly, just give your lordship the facts so it becomes easier to distinguish these judgments. Like I told your lordship, the primary point is that of ownership and title. So, first point was who conceived it, Idris or Ilyas?
Yes.
Now, there, my lord, his case is Ilyas coined new life, not Idris. There is now, my lord, here, and please see this, my lord. It's Yota Barcode, where is that notice? Where's my? But please give me one moment. I'll just show one note. Now, my lord, he has nothing to prove that Ilyas has been using it before Idris. Nothing. Not one document, not disclosed or showed. Now, we had relied on page 54 of GA2. Oh, sorry, vacate. Yes. Now, yes. Now,
yes.
Page 54. Now, this was a show cause notice issued by Dr. Idris, to Dr. Idris by the property tax department. Now, Lord, please see who it's issued to. Lord, your lordship is familiar with Hindi?
Yes.
So, my lord, your lordship will see Sri Muhammad Idris, possibly my lord, son of so and so, Muhammad Ismail.
New Life Clinic.
Dwara, New Life Clinic.
Yes.
Now, this, my lord, has been incorrectly translated. That should be 1975. There's a date there. You see the date in Hindi. Now, my lord,
16 May 1975.
yes. So that's the correct date. Now, we had put a translation which is on the next page. Now, there it's misprinted as 65.
It's 75.
It's 75. So, 75, Idris is the user of not New Life.
Yes.
Now, so Lord, I have one solid document to show Idris. He has no document. Nothing.
Yes.
One second, please, yet. Now, second thing, I'm losing track of points. I have to feed corner. He has no document. Now, my lord, does this document, my lord, line up and corroborate the case made out by me or the case made out by him? Lord, he admits in the Delhi suit, counter statement, etc., that there are 20 users. They include families of Dr. Idris, not Ilyas, who is one step down.
Correct.
So, Lord, the fact that they are using it and not just Ilyas's children, Lord, is completely supported by this.
Yes. Yes.
Now, instead of not providing any document to show prior user or user prior to this by Dr. Idris's son, what he says is, look, it's the custom to issue a notice to the head of the family. He treated it like not wedding invitations go to the head of the family. But a lawyer can do only so much to improve his client's case. Not it's changed, but not days have also changed. Not earlier, your lordship will remember, the invitation went to the head of the family, and it meant every member was invited. Now, look how days have changed. It never goes to the head of the family. Number one, it goes individually to Mr. So and so, Mr. and Mrs. So and so, or Mr. and Mrs. So and so, and family. And that family will include people below, not above. But the world has really changed. But if I can digress for 30 seconds, we come from a Jain community which originates from Murshidabad. So there is a place called Jiaganj and Azimganj. So it's a very small community, or it was. I remember through my childhood, but when there were weddings, standard procedure was there was no wedding cards, emails, nothing like that. Someone senior in the family went, told a few people, and the entire community was informed through them that, look, X is getting married on so-and-so date, you are invited. Everyone would turn up with children this small. The other quaint custom was that you are not permitted to give gifts. So there would be a person sitting there at the gate with a diary, and the most he would accept was 2 rupees, and it would be put in against the name. Then by 1980s, that became 20 rupees. So this is how it was. But my learned friend, he can only stretch it that far.
This has come to consideration in our Andaman. What has happened? 1969, there was a colonization. 1958 to 72. This Bangladesh peoples from East Pakistan have been deported to the Andaman. So at that time, revenue, no authorities and all these things. Who is the head of the family members? This land is 2 acres of land allotted to the head of the, either he is a son or is a father, is a mother, whatever, head of the family. So it has been given to the head of the family. Suppose he is the elder son, head of the family, elder son name has come. Time has gone. So in the revenue record, head of the family is the son. So thereafter, the brother sons also there. They have separated. Now after the death of the head of the family, so as per the inheritance, only the sons and daughters will get. The other family will not.
They are excluded.
That time nobody has thought about that.
No one.
So this is
Mr. Bhattacharya obviously thought of it very hard while not coming up with this explanation. Please see the smile on his face.
No. That is something which I have seen. It would be in the name of the patriarch of the family.
So, Lord, anyway, so this wedding invitation, Lord, as he treats it, nothing to beat this. And Lord, like I've showed your Lordship, everything else, Lord, falls in line with this document. Now, Lord, the strange thing is, I showed this also. My learned friend did not deal with it. What does his website say? Please take me Lord, page 13 of affidavit in reply to GA2. I showed this, no reply.
Affidavit in reply.
Not dealt with. Oh, you portion take to the
Page 13.
Yes. Now, this is not taken from his website, the plaintiff's website. And Lord, what does it say? Your Lordship has seen not the trademark. This is his website. At page 13, not extracted here.
Yes.
Now, my Lord, New Life. Now, my Lord, please see what's written there. New Life Laboratories Limited is one of the acclaimed and respected names in the list of industries engaged in manufacturing homeopathic medicines. We offer so and so. Lord, all those names are given. Lord, I'm sure a lot of these medicines I'll have to start using in Lord a few years' time. Then, my Lord, after that, please see after the names of the diseases. Under the able guidance of the founder, Dr. Idris,
who has experience of more than 52 years and the managing director of the Muhammad Ilyas.
So, my Lord, it's not Ilyas. It's Idris who founded this. Founder. So, my Lord, from this to say that, well, no, not Idris. This is the company, founder of the company is Idris. Now, my Lord, Idris is not there. There's no one to, my Lord, deny it. Mr. Ilyas is also not there. So, my Lord, he says, well, Ilyas he thought of it, he conceived it, and he waived his right in favor of the company. Then what did Dr. Idris do? No waiver by Dr. Idris. How does, my Lord, the company become the owner of the mark?
Yes.
So, my Lord, that's why he's run this case in the Calcutta suit, missing in the Delhi suit. Dr. Ilyas waived his right. Now, my Lord, Dr. Ilyas waiving his right will make no difference in any case if he's not the owner.
Yes.
Leave it. Okay. Now, my Lord, but the next aspect of this title was first is not who conceived of it. So, my Lord, I'm showing your Lordship, it is clearly Dr. Idris and not my Lord Ilyas.
Yes.
So, second point then is, my Lord, whether there's any transfer to the company. Now, this is the legal point. Now, my Lord, your Lordship may make a note. Number one, admittedly, there is no deed of assignment.
Yes.
That he now concedes because he has said by waiver.
Yes.
Now, this waiver won't do anything. Now, my Lord, I had made an argument based on section 42 and I showed judgments. This part not dealt with by my learned friend. He just tries to bypass it by using Gujarat bottling. But if your Lordship takes 42 once, Lord, your Lordship has seen it. I'll just,
okay.
Not if a trademark is to be assigned other than with the goodwill, then
just to interrupt Mr. Bachawat, we don't have a hard copy of the notes of argument. If I may share the soft copy with Mr. Bachawat and Mr. Roy Chaudhary.
The notes of argument? What? Oh, the file one. Oh, I see. Please share it. I won't have the chance to look at it, but
yes.
Now, my Lord, your Lordship will remember. But if I may just read, where an assignment of a trademark, whether registered or unregistered, now please mark this. So, whether it's registered or unregistered, is made otherwise than in connection with the goodwill of the business in which the mark has been used, or is used, the assignment shall not take effect, bar, unless the assignee, not later than an expiration of 6 months from the date on which the assignment is made, or within such extended period, if any, not exceeding 3 months. So, limitation, 6 months plus 3 months. in the aggregate as the registrar may allow applies to the registrar for directions with respect to advertisement of the assignment and advertise it in such form and manner as the registrar may declare. So, not mandatory to advertise.
Yes.
And get the permission of the registrar.
Yes.
And this advertisement is not by the registrar. Or so it's not that one puts a newspaper advertisement.
Yes.
So, we had showed one or two judgments on this aspect. I'm not troubling your lordship, but this part is mandatory. So, how does my learned friend get out of it? Not according to me, one can't get out of it. Whether it's registered, unregistered, you had to do it within 9 months maximum of the alleged, not assignment. So, he's been very careful. He doesn't say when this waiver took place.
Yes.
So, no date given either.
Yes.
So, how does he try to get out of it? He relies on Gujarat bottling. Now, please take that once. This is the sheet anchor of his defense now. If I may put it this way, no factual answer, legal answer. Okay, I'll pull it out then. But please gives me a moment. I'll just. I don't have it handy. Huh? Had a copy is down. Achha, I found it. I found it. I found it. Huh?
Yes.
But if your lordship has got it, my learned friend relied on para 13.
13 and 15.
Yes. So, my lord, to say that apart from a statutory right, a owner has, my lord, a common law right to license. Now, my lord, let's look at that. Para 13. Apart from the said provisions relating to registered users. So, my lord, please remember this is to do with licensing, not to do with assignment. It does not give him an answer on assignment.
The registered user.
Yes. So, not a registered user is a license, basically. So, his assignment part is not answered. Now, I had also said, look, you are saying you have given licenses to 50 people. There is no proof of it. So, he's saying, look, Supreme Court has said you need not. It can be oral. This is his argument. Now, para 13. Apart from the said provisions relating to registered user, it is permissible for the registered proprietor of a trademark to permit a person to use his trademark, registered trademark. Such licensing or trademark is governed by common law and is permissible, provided, nominal, please mark the remaining lines. The licensing does not result in causing confusion or deception among the public. 2, it does not destroy the distinctiveness of the mark. That is to say, trademark before the public eye continues to distinguish the goods connected with the proprietor of the mark from those with others. And 3, a connection in the course of trade consistent with the definition of mark continues to exist. And this is quoted from Narayan. Now, this part I'll have something to say with, but the more important part is later I have something to say. It would thus appear that use of a registered trademark can be permitted to a registered user in accordance with the provisions of the Act, and for that purpose, the registered proprietor has to enter into an agreement with the proposed registered user. The use of the trademark can also be permitted, derogates the provisions of the Act by grant of a license by the registered proprietor to the proposed user. Such a license is governed by common law.
It is the case of the plaintiff.
Malad?
It is the case of Mr. Bhattacharya.
Yes.
It is the common law.
So common law, he's saying no. But according to us, Trademark Act doesn't permit it. He is saying no.
Correct.
You can do so. Gujarat Bottling says so. Now, firstly, this portion does not say that there need not be any writing. He used it for the proposition that, look, I can give it orally. Now, this judgment is not an authority for the proposition. But what my learned friend has possibly missed out is that the law has changed since Gujarat Bottling. Gujarat Bottling is 1995. Trademark Act has come into force in 1999. Now, there is one major difference between the old Act and the new Act. And that I'll show your lordship. But your lordship will have to take a tattered copy of my Amatta down. Amatta down. want to compare it. I don't know where you have got it from. You just see it. Now, let me just compare it. Relax here. And the shortcut corona, please now.
Yes.
But I'm just comparing it before I give your lordship the old mark, old act. Not. Yes. Now, this is a printout taken from the schedule to the book. But I happen to have an old copy of the 58 Act. It's a little tattered, but now, my lord, if your lordship takes 2M, and Lord, may I trouble your lordship with something more? Right, a trademark as well. Lord, please also take the new Trademark Act, Lord, and if the equivalent section, which is 2R, Lord, next to it, it will be helpful. 2M. 2M.
Is the mark.
Now your lordship will see, Lord, that 2R is a lot longer. The new one is a lot longer. So what has happened is, Lord, your lordship will find a additional part has come in, Roman 2. And look at the difference now. Lord, if I may read the old act first. Permitted use in relation to a registered trademark means use of a trademark, one, Lord, please mark this, by a registered user of a trademark in relation to goods. Now, Lord, permit me to not add something which your lordship knows. A registered user is a licensee who takes the license to the registrar, has it registered over there. So that's a registered user. So this is considering a part where there is a registered user. 2, which complies with any of the conditions or restrictions to which the registration of the trademark is subject.
Yes.
So, Mulot, this is all that there was. Now, Mulot, take the new act. Now, Mulot, see what is coming. Now, R Roman 1 is the same. 2R Roman 1 is the same as 1.
Yes, in relation, yes.
More or less the same. I don't think there's any radical difference. Now, Mulot, 2M2 is now completely different. 2M2, as it stood earlier, was which complies with conditions, restrictions. Now, Mulot, please see it now.
By a person
other than the registered. So, first part is dealing with registered. Second is by
proprietor.
Correct. By a person other than the registered proprietor and registered user. So, meaning cases where there is no registered user agreement.
Yes.
So, all other cases are now falling here.
Correct.
With which he is connected and in respect of which the trademark remains registered by consent in a written agreement. 58 Act did not require written agreement. So, in 1999, the Act changes.
Yes.
And it says that, look, permitted use relating to a trademark
yes,
falls within 2 categories. 1, where there is a registered user agreement. 2, where there is no registered user.
Yes.
In that case, also you need to show a written document.
Yes.
So, Mulad, Gujarat bottling, on the question of licensing, at least, Mulad.
That is before the act.
And on assignment, of course, he is not, it can't apply to assignment. So, for assignment, he has to comply with 42. No answer given to that. For licensing, he says, look, he has got 20 people. I've showed your lordship on fact, affidavit, people saying, look, I have no agreement with him. Other family members, affidavit is on record, not dealt with. My learned friend says, look, I am saying they are all my licensees. I don't have a document to show it. Okay. My books don't show I'm collecting revenue, but I'm collecting revenue. You must believe it. This is his case. He just meets it by this blood, Gujarat bottling, which is no longer blood applicable, this portion.
Yes.
Now, my lord.
Yes.
Not this deals not very broadly with this aspect of not title. In my humble submission, he has not answered this at all. The one answer which he had was not a answer out of Gujarat bottling. His second answer was that Sriram's case, which I show your lordship, was based on a admission before the registrar that, well, it's common to the trade. Here also he is admitted there are 20 users, not his own case in Delhi. So, not that family marks, there can be no exclusivity amongst family members was the proposition in that judgment. That proposition is not denied.
Yes.
He distinguishes it on facts. So, not this takes care of one part of the argument. The second, not the other parts, not are really more matters of prejudice and fact. In reply, I don't want to deal with it in any detail. Not the judgments I'll deal with, but not the second part was this suppression. We have run a point of suppression, not Delhi suit, pleadings, the case run there, the complete contradiction in case run here, both on the aspect of ownership, licensing, who is there, who is not there. But there's a pleading over there also, your lordship will find, not in the plaint, page 185 to the of the vacating application. There also one more contradiction. Case in the Delhi plaint. But if your lordship takes the vacating application, page 185. Volume 2.
Volume 2.
Page? But page 185. But there are contradictions galore. Naturally, my learned friend had a difficult time not trying to cover it in this Calcutta suit. Your lordship has come to 185, but last para 8. That the said trademark name New Life, though started to be used in the year 1970, however, it is the brainchild of Dr. Mohammed Zakaria to expand the business and enter, etc.
Yes.
Now, what does brainchild mean? I'm not very sure. Not just like this plaint is my learned friend's brainchild, no doubt. But not this brainchild of Dr. Zakaria, please see the rest of the sentence, to expand the business and enter into manufacturing units, own brand trademarks, who started manufacturing, etc. So now, Dr. Zakaria becomes the owner. So, there is definitely an air of mystery about the title.
Yes.
Now, on this suppression about Delhi, there were two other very small aspects. My learned friend had dealt with it. I'll just touch it without not. But one was, he had made the submission that the matter was heard repeatedly on merits. And when he saw he's not getting an interim order,
that you've shown the orders.
He's shown it. I am not troubling your lordship. Now, the strange thing is, please look at the order we got. But it's something which we had also missed. But since Mr. Rudraman tried to meet it, please take page 149, 148 of GA2, volume 2.
Yes.
Page 148. It's not, I point out it's our mistake. We should have made this argument earlier. I'm making it for the first time, not in reply. Mr. Bhushan, counsel for the plaintiff, enters appearance, seeks to withdraw the suit. He states, now this is a statement, that the plaintiff wishes to institute a suit in a court of competent jurisdiction in light of the order passed by the court on 21st July, observing that jurisdiction may not lie with the court. So this is submission. Now, please see the order. Accordingly, suit is dismissed as withdrawn. Where is the liberty to file afresh?
Lord, if Mr. Bachawat is making it for the first time, then I wish to rely on one judgment of Bengal waterproof, because it's a continuing cause of action. I will just add that judgment.
No, that's fine. I'll deal with that. So all I'm pointing out is, Millard, this leave is also not there. I've pointed out that we had missed it. It's something he should have also pointed out.
Yes.
Now, my lord, as I understand it, not when one is withdrawing a suit, there are two ways of doing it. One is a return of the plaint under Order 7, Rule 10. The court has not ordered return over here. It's not a return. It's also, but in that case, his suit would have had to be the same. The story could not have changed. He would have fared possibly worse than in the Delhi suit. And the second is not to obtain leave to file, not to withdraw and to file afresh. That leave is also missing here. So,
yes.
Now, my lord, we had also not talked about this change in stand, and my lord, your lordship had jokingly observed, my lord, your lordship my lord, loves my lord, pulling our legs, but it's obviously, my lord, the author is a better author over here. My lord, your lordship has given credit to the author. So, my lord, that really can't be, my lord, an answer for the client. So, my lord, suppression and all that, my lord, I'm not touching it. My learned friend had covered it. Now, my lord, coming to the other small issue over here, which is the trademark issue. My lord, till now, ownership, suppression, other points. Now, my lord, coming to trademark. Again, my lord, very limited exercise. But let's just look at it like this. My learned friend has a registered label mark. Now, my lord, please take that label mark once. Page. I'll put it. I'll leave my brief. But please take page 27.
Of J2?
Of J1.
J1.
J2, very well. Not page J2. Are you sure? This is not J1. I'm sorry. Not
J1.
But with technology, life has become a little confusing. Earlier, one only had the papers. Now, something is in iPad, something is in papers.
Yes. Page?
Page 27. Not this is part of his plain petition. So, my lord, your lordship is to judge. My lord, this is really what is before your lordship. I've showed your lordship the para from the plaint. My lord, he admits today his right is because of registration. Passing off goes out of the window. Infringement. So, my lord, now on the left side is his registered label mark. Not it's something that I don't need to say again and again, but the fact is registration of the label does not give him the individual parts, it gives him the label as a whole.
Yes.
So he can't claim New Life, nor can he claim laboratories, he can't claim private, he can't claim limited, he can't claim the leaf. It's the whole thing as a whole. That's his registered mark. Now, Millard, on the right side is my mark. On that same page.
Page?
Page 27.
27 of J1?
Yes. But there's a table like this, chart. No?
That is the
J1.
paragraph.
J1, page 27. That's his suit.
That is the readings.
But could I just see, Millard, or why? Huh? No, I'm sorry, Millard, it should be GA2. It should be GA2. I'm sorry. No, but this is part of his petition. So it'll be there also. It'll be there. Can I just give it from there only? But please take para 26 of the petition. Yes. Yes. That's the one. But the pages won't tally, but
no, J2 it is.
Yes. Very well. Now please take the two marks side by side.
Yeah.
Left side is registered mark, right side, your lordship is concerned with the label on top, not the New Life below. That's not in use by me. Now, because of what your lordship remembers, he filed in Delhi, didn't get an injunction. Mother said change, wife fight it out, so this change. Now, my lord, how can the label on the right be said to be an infringement of the label on the test on the left? No, that's the test over here. Label versus label, you compare the label and that too, not even a side-by-side comparison. Now, my lord, the word New Life is absent on my mark. It's not there. NL is there. Now, my lord, he has one leaf in a completely detailed manner. Mine is not a completely different two-leaf approach. So, my lord, applying the test of infringement, my lord, I'll take his test to be, for the time being, correct, although it doesn't apply here. Are you saying something? Now, I'm not taking his test. He said that the test is you compare the essential features of the mark. Now, Milord, let's look at his mark. What is the essential feature of the mark? Not keeping my mark aside. If one looks at it, one would say it's new life. That's what is written in big. That's the bold part of it. Leaf, people may or may not remember. I don't know whether he would say that's the essential part of it. But I would assume that new life and not even laboratories. New life is the essential feature of the mark. So if your lordship is to compare that with my mark, which is the test, even not assuming that is essential feature test is to be applied in a infringement action, Lord, one cannot say new life is there at all in my mark.
Yes.
So, Lord, applying the test which he relies on, there can be no infringement. Passing off different thing. I'll come to that.
Yes.
Now, the one below that, new life, please see, used on shop cum clinics. Not by me, other family members. Other family members. So now, my lord, applying the essential feature test, my lord, the lordship is looking at infringement. My lord, let's remind ourselves once, my lord, of the act. My lord. Please, my lord, take the section on infringement now, my lord.
Yes.
But please take Lord, section 29 once. But I am sorry, not to trouble your lordship with a basic thing, but not 29(1). A registered trademark is infringed by a person who, not being a registered proprietor or person using by way of permitted use, uses in the course of trade a mark which is identical with or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered, and in such manner as to render the use of the mark likely to be taken as being used as a trademark. Then, number 2. A registered trademark is infringed by a person who, not being a registered proprietor or person using by way of permitted use, uses in the course of trade a mark which, because of identity of the registered trademark and or similarity of the goods or services or similarity of registered trademark. So, my lord, again, it's back to identity or similarity of the trademarks is likely to cause confusion. So, my lord, this is the situation. Now, your lordship will see subpara 3. In any case falling under 2C, the court shall presume likelihood of. So, my lord, A and B, no likely, no presumption.
Correct.
So, my lord, in this case, C, he will have to show identity of registered mark and identity of goods. Now, identity of goods is there. 29 to see where there is a presumption will only apply where there is identity.
Identity with the registered trademark and the identity of the goods.
So in this case, identity of goods is there. I'm not disputing that. But he has to show, not for it to be infringement with deemed deception,
Covered by such registered.
there must be identity.
Correct.
In this case, my lord, ex facie, there is no identity. Now, my lord, how does it make a difference? Now, my lord, I tell your lordship, but one can take one principle from here, another principle for there, and mix it up and hope that it produces something new, but it can't. My lord, oil and water don't mix. Please remember, this is a label mark, not a word mark.
Correct.
All the judgments which my learned friend relies on are to do with word marks.
Correct.
Word marks registered.
Yes.
Every judgment is showed word mark registered. Here there is none.
Yes.
So you can't use that principle and mix it up with mine. Identity of the label. You can't say, look, new life. NL, if I stretch it hard enough, NL becomes new life.
Okay.
Or I shorten my new life and make it NL. No, that's not the test. That's not the test.
Yes. Next.
So, my lord, therefore, my lord, even on the test of infringement, and my lord, your lordship has read the para where he now admits everyone is entitled to use it. But now I have a registered mark. I have the right to exclusive use. So it must be based on infringement. I'll not therefore trouble your lordship with the passing of part. I had made these submissions earlier. My learned friend has not dealt with this. So now, my lord, I think that should be
Any further?
Just give me 1 more minute to see what else I need to deal with. Please give me 1 more minute. I think factually we are done. On principle, we are done. Yes, one second, before that. Lord, I had also, at the beginning, Lord, said that although he has no right to stop me, I'm willing to change the label. His objection, as I've understood, I was not there when my learned friend gave the reply, is now that, look, two things. You are using the old name, my learned friend has showed your Lordship Companies Act. I was not required to change it, I changed it. But the law now requires me, it's mandatory for 2 years. Correct. To give the old name. But I'll remove it after 2 years. Number two, Lord, his other objection is, look, green. Now, my Lord, I had given your Lordship a bunch of my change marks. I'm willing to change it without prejudice, not without any finding against me. Not, I'm willing to do that. Not just to buy peace, it's a family matter at the end of the day. Not, I've advised them and they've been gracious enough to say, very well, if you say so.
Yes.
So, Lord, that part, Lord, I'm saying I'm willing to not change green. My learned friend hasn't dealt with it. So, Lord, this is the second part. And Lord, Mr. Roy Chaudhary had showed your Lordship that I have one other new registered mark now. You showed it, right?
In the reply.
It's not annexed to the reply. Just show that. But please see the reply to TA2. Right?
Yes.
Well, I am not conceding. I'm not conceding that I will not change it to this, but if your Lordship comes to page 25.
Dr. NL.
Dr. NL, I have this registered. He can't have a case of infringement anymore in any case.
Yes.
But not leaving that aside. He has no objection to Dr. NL, but he made a lot of noise about not Doctor. I tried to use Dr. Ilyas NL. Now, Lord, he can't have objection to use of my father, nor is he claiming Ilyas as a trademark. Please remember that.
Yes.
I have this, Lord, as far as this is concerned, Lord, again, fully without prejudice, Lord, if your Lordship says, I will use this, but not with one rider. One rider only, existing stocks, Lord, all lying there, Lord, we have been restrained, not huge amount, not we've suffered huge losses.
Should not be suffered.
Not huge losses, not we've suffered. But please see, 6 to 8 months, not my business has been completely.
Yes.
Not even after expiry of the interim order, Lord, I'm instructed by Lord, he's ascertained. Even after expiry, we did not sell, Lord. And Lord, we won't have time. 12:30 is what something else. But on the judgments, there's not much to say. But other than his cases are all that of registered marks. If your Lordship wants, I can put in a one-page note. Otherwise,
Give notes if you want.
If your Lordship not permits that, we'll do it. Otherwise, it will involve coming back again, a reply to reply.
Give the written notes.
Just with the judge, distinguishing. But only distinguishing the judgment, or your Lordship wants a
total, give
formal?
The total.
Oh, your Lordship wants
that will be better.
May
I just take 30 seconds, my lord, one judgment, because Mr. Bachawat said that there was no leave. My lord, 1997, I have a soft copy, Mr. Munshi has it. 1997, 1 SCC, page 99. My lord, I will not trouble your Lordship. My lord will kindly come to head note C. It's in paragraph 10.
1997?
1 SCC, page 99. Bengal waterproof. A passing off and an infringement is a continuing cause of action, my lord. So there is no bar, even if such leave is not granted.
Back.
Yes. And my lord, I will hand over.
But I'll distinguish it in 5 seconds. He's taken.
I just one more thing. And my lord, Mr. Bachawat had relied on page 110 of that affidavit of that uncle of the director of my client. My lord will kindly just make a note at 110. He does not say Dr. Idris had coined it. In 111, rather, he says it was Dr. Ilyas. And this is an affidavit affirmed on after the interim order. But not, as your Lordship knows, it happens within the family. Some is with us, some is with them.
Okay.
Now, Lord, that dug back, if I can take 5 seconds. Lord, this is a case of order to rule 2, not order 23.
Yes, order to rule 2 sub rule.
Yes. Order 23, different compartment. If you withdraw, you must have leave. Number two, my lord, there is no.
No,
and-
Mr. Bhattacharya is having good argument on Order 23, Rule 3.
He is my leader. He was my leader in the appeal.
Which one? Which one?
That Bengal Energy.
In
Bengal Energy, the bank guarantee. Where my
And
lord.
lord, the second point. Oh, that one. I see. And lord, the second point is, if he says continuing cause of action, he's entitled to where's the pleading in his plaint, not that. That's all, lord. But your lordship gives a reasonable time to file the notes, lord.
Tuesday?
The lordship gives it Wednesday.
Wednesday. So appearing for the plaintiff. So I am fixing on Friday. So appearing for the plaintiff. So appearing for the defendant. And the plaintiff has filed the written notes of argument after serving the copy to the learned counsel for the defendant. Let the same be kept in the record. Counsel for the defendant concluded his argument. Full stop. Defendants are directed to file the written notes of argument by 7th of March 2025. Let the matter appear on 7th March 2025 as to be mentioned only for filing written notes of argument by the defendant.
Well, the interim order.
Order needs a correction. Your lordship has said concluded arguments. Your lordship should say concluded arguments in the nick of time. 12:30 dot.
Well, the interim order.
Counsel for the plaintiff submit the interim order. Ganta delay is going to expire today. Accordingly, interim order is extended till the disposal of this application.
Deeply obliged.
And lordship, we also have an amendment application to which they have not objected to, so the same may be allowed, lordship.
Oh, I see.
Acha, you take this. Manu to share that. The plaintiff has filed an application being GA Form 4, GA4.
Yeah.
GA4 of 2025, praying for amendment in the plaint on the ground that the defendant has changed the name from NL Care Private Limited to Aprive Healthcare Private Limited. Full stop. Consider the submission made by the counsel for the plaintiff, peruse the amendment as sought for. This court find that the amendment sought for by the plaintiff will not change the nature and character. It will not change the nature and character of the suit. Accordingly, prayer A to C of the master summon is allowed.
Two things. I have not used opposition. Allegations in it are deemed to be denied.
Leave to re-verify the claim, my lord.
And lord, the second thing is we have changed our name to Amway, not Aprive without prejudice to our.
Full stop. As the defendants have changed the name from NL Care to Aprive without prejudice to his old name as NL Care. Full stop. The defendants have not used the affidavit in opposition. The allegation made therein are deemed to have been denied. GS so disposed. Yes, call the list.
May I please, your
My lord. My lord, there are two applications. GA5, my lord, is my application for analogous hearing because, my lord, relating to the same deceased, my lord, there two wills have been propounded. One is of 2002, which has been propounded by my learned senior friend's client, and the other one is by our client, my lord, which is a later will of 2004. Now, my lord, both of them have filed applications for probate, and both of them have been converted to testamentary suits, my lord. My lord, there was a direction for this application to go out of the list, as my lord had indicated on the last occasion, because this was filed, my lord, when it was still a PLA. It had not yet been converted, my lord. Now, both of them are testamentary suits, my lord. They may be heard together. That is GA5. And GA4, my lord, is my application for appointment of an administrator pendent illitem, my lord. That, my lord, I'll have to.
Actually, if I may just indicate, as far as my learned friends IAGA 5 is concerned, there's already an order to that effect. Your lordship will find that order on 12th April 2024. It says that this matter should appear with testamentary suit number 6 of 2023 on the date fixed. So this order is already existing.
But it has not been, my lord, appearing together. My lord,
Lordship, the order was passed on 12th April 2024. Lordship, in testamentary suit number 5 of 2021, the order was passed on 12th April 2024.
Yeah, 12th April 2024 order.
Your lordship will kindly take the last line of the order. This matter should appear with testamentary suit number 6 of 2023 on the date fixed. So both, there's already a direction for both the suits to appear together.
Evidence is also going on.
Lordship, as far as this suit is concerned, TS5, the cross-examination was ongoing. We can bring the witness whenever your lordship fixes it. The main matter, TS6 is fixed on. Your lordship will find TS6 was fixed on. Lordship, on 19th of March 2025 at 2 p.m. If your lordship so desires, we'll bring the witness on that date. The cross-examination may be completed.
There's just one thing.
Number filed a supplementary affidavit. The executor wants to file a rejoinder in liberty. Let the matter should appear with the testamentary 6. Where's the testamentary 6?
Lordship, may I hand over the
What is the stage of the testamentary 6 now?
Lordship, this is the last order passed in testamentary 6.
Key stage.
Your lordship has fixed it for witness action on the 19th of March 2025 at 2 p.m.
Correct.
So, lordship, even we'll bring a witness. The cross
This TS6, you are the plaintiff.
TS6, they are the plaintiff, and TS5 is my suit. I'm appearing on behalf of the
TS5, what is the stage of the TS5?
Lordship, TS5, the stages of cross-examination.
TS5. And TS6?
In TS6, the witness action is about to start.
Of the plaintiff.
Of the plaintiffs.
But in TS6, we have got this GA, TS5, we've got this GA, which is essential because there is an allegation of waste and or ruin of the property, which is the subject matter of the conflicting wills. In such a case, ordinarily, and we have case law to support this, that ordinarily an administrator is appointed for the purpose of taking over the property and ensuring that the rents, issues and profits thereof are set apart and kept, so that ultimately whoever succeeds, whichever will is appropriately probated, then, my lord, it will be distributed accordingly. If none of the two wills is probated, it will go the interstate way. Now, for that purpose, my lord, our application GA 4 of 2023 is on board. Now, I was humbly praying this, my lord, the application, my lord, affidavits have been exchanged. It was in fact being heard by my lord's predecessor. It has been heard on a number of occasions. We had completed our arguments. They were supposed to argue. By that time, now there's been a change of counsel and advocate on record on their part, I feel. Now, my lord, if this application can be heard out any day, including whichever day next week my lord fixes, I am not suggesting that this has a bearing on the trial, but this has a tremendous bearing, my lord, on what is happening now. We say that part of the property, which is admittedly the subject matter of the two conflicting wills, rents, etc., which are being collected.
Now, who is taking the benefit of the rent?
The executor is taking. The executor is taking.
Now that is being done according to them. They are the executor. According to their purported will, they will say that according to my purported will, we are the executor. They are in possession. They are the persons who are actually taking, my lord, the money. We are told that
you are also one son.
Daughter-in-law.
I am one son's legal heirs. Now, my lord, so therefore there is this conflict. This has to be resolved in trial.
Daughter-in-law.
This has to be trial. Very well, the divorce doesn't matter that much. As far as the matter, the subject matter in dispute is concerned, in order to prevent any of the parties from dealing with it or siphoning of whatever is coming out to his benefit without the same being accounted for, an administrator is necessary. That is why, my lord.
Yes.
Let my learned friend place his application. We are here before your lordship.
Yes. Now, my only difficulty today, I'll tell you, lordship, is we are instructed by Miss Kumkum Mukherjee. She had to leave, my lord, for some urgent business, I am told, of a personal nature. So, my lord, I am humbly submitting. If not today, the next day, which my lord takes up interlocutory matters, my lord keeps it high on board.
my lord, we'll come and argue it out. If your lordship wants, my lord can also, my lord, if it falls, comments to your lordship, my lord can fix up a time if your lordship so desires. It will take us hardly 20 minutes each, my lord, to address your lordship on that. I'm not suggesting that trial should be stalled for this, but I am humbly submitting that GA4 is a trifle urgent.
Oh, TS6 is fixed on 19th March.
Yes.
At 2 p.m.
Yes.
And it is your witness will come. Your witness will come for examination chief, and then you will cross-examination. And in other TS5?
Your Lordship, the cross-examination has already commenced. Your Lordship will find an order dated 3rd February 2023 passed in TS5 of 2021.
3rd February 2023?
Yes, my lord. Your Lordship will find on the prayer day the suit is adjourned and shall appear in the list on 10th February. It is made clear that no further adjournment will be granted since the plaintiff's witness has been partly cross-examined and is on oath. I'm sorry, my lord. It's slightly
Okay, no problem. Then what I propose to do, so let both the case be fixed on the same day for the witness action. And with regard to hearing on the GA4, I am fixing one date.
Yes. Obliged. Deeply.
So appearing for the plaintiff in TS5 of 2021. And so appearing for the defendant in TS5 of 2020. So appearing for the plaintiff in TS6 of 2023, and so appearing for the defendants in TS6 of 2023. It is fine from the record. TS6 of 2023 is fixed on 19th March 2025 at 2 p.m. for witness action of the plaintiff witness. It is submitted by the learned counsel appearing for the plaintiff in CS5 of 2021 that in the said case, the plaintiff witness number 1 is to be cross-examined. Is to be further cross-examination of the plaintiff witness is to be resumed. Accordingly, this court is of the view both the matter be fixed on 19th March 2025 at 2 p.m.
On 19th of March, I am, my lord, in your lordship's territory, my lord, at Port Blair. I have a matter. Kindly fix it.
19th March?
I have a matter fixed at Port Blair. I'll be closer to, my lord, Port Blair, my lord, and Corbin's Cove than, my lord, Calcutta.
So it is a better view. You can sit in the Caveator scope and the video conferencing,
Lord,
and don't wake. As far as I can also enjoy the view of the Andaman.
My difficulty is with such beautiful surroundings, I might forget the.
So 19 March, this will also not.
19th, any other.
So this also will not be taken.
Yes, both if they.
So then I will fix the April. Then it will go to the April.
Yes,
well, leave it to your lordships. We are ready.
Date the 19th April में कौन सा डेट है 20 क्या बोला लास्ट में क्या बोला no 19 both the matter be fixed on the same day so that both the witness can be examined and cross-examined. Full stop. Though the matter is fixed on 19th March for witness action in connection with TS6 of 2023, with the learned counsel for the plaintiff is having some difficulties on the said date and paid for fixing another date for witness action. In view of the submission made by the counsel for the plaintiff in TS6 of 2023, hearing of the case on 19th March at 2 p.m. is adjourned. Let TS5 of 2021 and TS6 of 2023 be placed on, give the date, 25th April at 2 p.m. Can it be continuous to date?
As far as the cross-examination is concerned, I believe it can be concluded on that date because they have already done most of the cross-examination.
I am fixing 2 dates. Let us see. 25th of April and 28th of April 2025 for examination and cross-examination of the witness in both the cases. Full stop. It is also fine from the record the plaintiff in CS 15 of 2021 has filed an application being GA4 of 2023 praying for appointment of administrator pendant light. It is submitted that pleadings have been completed and the matter is to be heard expeditiously. In view of the submission made by the counsel for the plaintiff, let GA4 of 2023 be in connection with TS5 of 2021 be placed on placed on 12th of March. 12th March? No, ये कब बृहस्पति होता बृहस्पति and शुक्र Friday, only Friday होता. Then when 21st March. On 21st of March 2023
is an island of holidays for us.
13
to 17. 13 to 17.
Come with the fresh air on 21st.
This air will be Goa. That air will be Port.
In both his instructing person is right next to him.
But you are tempting me to leave this chair and go to there.
I must say, my lord, I went last month. We always go to Corvin's Cove. Whenever we come, we get down from the airport, we rest a bit, do the matter in the court, and then go to Corvin's Cove. This time, after a long time, I have found that the water level which is there is higher than ordinarily.
Okay. 21st March.
So next time, my lord
For
is there.
hearing of
My lord may visit Corvin's Cove first before going home.
No, during my practice, after finishing on my all work, because in Andaman we start our chamber work from 5 o'clock. Because 4:30, 5 o'clock. After completion of 8:30, 9 o'clock, then I used to visit that round.
That round once and then go back.
One, then I come with a fresh mind.
The only difficulty my learned senior friend never tells from before. An excellent musician, and we get to know only much later that he was there.
So next time we go, we'll take him with him. And Corvin's Cove is the best place for music. I'm sure it will inspire him also.
Okay, thank you.
Obliged, Lord. Declare.
My lord, appearing for the defendants, I'm representing my senior Rajdeep Bhattacharya.
Yes.
And Rajdeep Bhatt, in courtroom number 237, there is a matter in fixed in 12:30. So we're praying for not today. In next week, fixed.
Not today. As so appearing for the petitioner, plaintiff. So appearing for the defendant, you are for the
defendant.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 7th March. Next.
Lordship, I beg to be appear on behalf of the Caveator. As per your Lordship's desire, we have given them inspection, but they have not taken the inspection. But
Court never desire, court only order.
but they have not taken the inspection, but they have taken the affidavit of documents. We have supplied those documents.
But I'm ready with my affidavit of documents as well. They can.
You filed. Suggested issues.
But issues have to be framed.
Yes, your Lordship would kindly give us some time to get back with the suggested issue.
Not come with the suggested
issues. Today I have not time. Lordship may frame the issues right.
Only one will.
Only one will.
So what is the
Lordship kindly gives me some time.
No, there is nothing else. There is only one question.
Will matter.
You have challenged the will.
Yes, that is the question. Whether the will is valid or not. That is all. That is all.
Gives me a week's time.
Suffering for the plaintiff, suffering for the defendant. Both the parties have filed their affidavit of documents. Let the same be kept with the record. Counsel for the parties press for time to exchange the suggested issues. Let the suggested issues be exchanged. List the matter on 7th of March for framing of issues.
But thereafter, judge's brief of document I have to prepare. So, Lordship may pass the direction today.
The plaintiff is also directed to prepare the judge's brief of document within a week.
No.
Prepare. Is also directed to
4 weeks.
No, 4 weeks.
But in the
okay, then on that day I will fix because
very
get it.
Great.
Next.
Lord, Lordship directed discovery and inspection. Lord, the documents we have.
But I forgot to file the affidavit of documents.
I have recorded that.
Great.
Lord, we need 2 more weeks. The executor was not in Calcutta, my lord. He was traveling. He's coming back on Monday.
Which?
My lord, in the next matter. That's 64.
64.
We have written to them to take inspection. Lord, they haven't been able.
My advocate was also traveling. We'll do it within a week. If my lord grants us only a week, we'll complete.
Grants us 2 weeks, my lord. We'll. I'm led by Mr. Ray. He's on the virtual.
Appearing for the plaintiff. Appearing for the defendant number 1.
No, I appear for defendant number 2.
Who is for the defend number 1? Nobody. Defend number 2. Counsel for the respective parties prays for extension of time to complete the discovery inspection.
Yes, my lord. And file the affidavit of document.
Complete the discovery inspection and to file affidavit of document. Considering the submission made by the counsel for the parties are directed to complete the discovery and inspection of the document within 3 weeks.
2 weeks, my lord.
2
We'll do
weeks,
it.
comma, affidavit of document refiled within a week thereafter. In the meantime, the parties are also directed to complete this exchange the suggested issues. List the matter to be on 4th April for framing of issues.
My lord, in that case, my lord, there's a subsisting interim order. Perhaps, my lord, that's
The counsel
expiring.
for the defendant.
I'm the defendant number 2 petitioner, my lord.
Hmm.
My lord, I extended the interim order till 27th March. My lord, we kindly extend that as well.
The interim order to 27 March.
Yes, my lord, I had granted this day before yesterday. 26th February, I had mentioned it. It was expiring. My lord, I have a copy of the order. If my lord.
The interim order which was extended till 27th of March 2025 is extended till 11th of April 2025 or until further order. Whichever. Great. Next.
My lord, I'm for the petitioner.
Yes. Completed discovery inspection.
Yes, my lord. Yes.
Affidavit of document, my lord.
Issues there.
It's my affidavit of documents. I'm
Com-
serving the copy.
Have you exchanged the suggested issues?
Yes, my lord. I have. These are my issues. Suggested issues.
You have not come with the suggested issues.
I have not served, my lord. This is my suggested issue.
Only one will, na?
Only one. No.
Probate petition is barred by limited. So why barred by limited? What is the date of the will?
Yes, kindly see. Date of will is, my lord.
2011.
Yes, my lord.
2011.
Yes, my lord.
And when he died?
Died, my lord. Page 10, my lord. Date of death, my lord.
2015.
15, my lord.
2015.
15.
11 died 15. File on 2022.
22. 3 years already on, my lord. There is no any explanation.
Huh?
There is no any explanation. 3 years already passed, my lord. Prior to the suit was also filed, partition suit. There is no any disclosure.
Whether the testator duly executed the attested will corresponding as per the provisions of the Succession Act. Is there any provision of Succession Act for whether signature testator appearing in the alleged will for the so-called executor has sought to grant the probate is indeed the signature of what?
At this Bengali date and English date and not match, my lord. The will. The father's name was not in the will. Also, the date of age of the testator is not match is the document, my lord. Also, all are, my lord, hurriedly drafted, my lord, after the death, my lord, and my lord file it, my lord. Also, there is previous will also, my lord, that was not. Father's name was also not disclosed, mentioned in the will. Age was also not mismatched. Date of Bengali date and English date also not mismatched, my lord.
Your one is okay.
Yes,
I am not taking 2. 3 is okay. Whether signature attested appearing in the eligible for the so-called executor sought to be granted for probate is indeed the signature of testator. Whether the will dated so corresponding to so for granted probate is free from suspicious treatment. Then so-called executor undue free from courses, then 5 of the 5 will not come. I am not taking the 5 because free from it will undue influence it cover. Whether the indication of the personal interest of the executor, the contents of the will, or the exact opposite contradictory to the facts of proof or documentary evidence, that is not required. 6y. You prove cross-examine whether it is a matter of suspicious before the Honorable Court. The English calendar date of the execution of the will
that
is
is a
not
vital
the
one.
corresponding to the Bengali calendar date is an outcome of the hurried intimation and imitation of the will short time after the death of whether the age of testator mentioned in the will is correct and matching with the official document of the testator. That you prove that is not necessary. Whether the suspicious missing in the testator's father name from the testator induction in the will is evidently hurried limitation. Probate of the will can be granted by this evidently document is not genuine. Yes, record now. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Both the parties have filed their affidavit of documents and suggested issues. Let the same be kept with the record. After hearing the parties, going to the pleadings and the suggested issues, following issues of friend. This one, plaintiff one, this one. This one, okay? 1, 2, whether the probate petition, this is 3, this is 4, 5, 6, 7. I am taking your 1 and 4. 1 and 4 and defendants, I am taking 1, 3, 4, 6, 7 and 9. The plaintiff is directed to file the judge's brief of document within 4 weeks.
4 weeks.
After serving the copy to the learned counsel for the plaintiff, full stop. You will adduce evidence.
After that, my lord.
Full stop. I am fixing a date.
Yes, sir.
Let the matter appear on. Give the date for witness action.
Lord, kindly be at after 3 because he is the practicing advocate in this court. The witness is practicing advocate in this court.
April, I am fixing.
Yes, my lord. After
Let the
3,
matter appear on
3 p.m. or 3:40.
22nd April, 3 p.m.
Yes, deeply.
For witness action. Yes, next.
I am appearing on behalf of the plaintiff, your lordship.
Yes.
Pursuant to your lordship's last order to the
Framing of issues.
Yes, your lordship. We had done our bit for the discovery and inspection of the documents. We had supplied to the defendants the affidavit of documents within time and offered them inspection of the document. But no one came forward on their behalf. May I file the affidavit of documents, your lordship? And your lordship,
yes,
I am ready with the suggested issues, your lordship. But however, I could not prepare the judge's brief of documents. Since
yes.
The advocate record was unwell. He was suffering from various ailments.
Since when?
He is suffering since January. And now he has continued attending office. So please extend to give me 2 weeks.
Have you informed?
I have not informed them.
Then?
On the previous occasion, we had mentioned that the advocate is unwell.
The order was passed on 21st of January. Now we are on 28th of February.
I have given the letter.
More than 1 month has been passed.
Lordship may grant me on
what
2 weeks.
What illness he is suffering from?
He had suffered a stroke actually.
You could have been informed the other party.
That was our mistake on our part.
How soon you will disclose the document?
Within 2 weeks, your lordship.
Huh?
Disclosing
the document of 2 weeks. So and so suffering for the plaintiff, so and so suffering for the defendant, full stop. The plaintiff has filed, plaintiff submitted, the plaintiff has already disclosed the document to the defendant and has filed the affidavit of document. Let the same be kept with the record. Counsel for the plaintiff further submits that the defendant has not disclosed the document, and as such, the plaintiff could not able to inspect the document of the defendant. Counsel for the defendant submit that the advocate on record of the defendant is suffering from illness, and as such they could not, and as such the defendant could not able to disclose the document for inspection. Counsel for the defendant prays for 2 weeks time to disclose their document to the plaintiff for inspection. In view of the submission made by the counsel for the defendant and for the interest of justice, time to disclose the document by the defendant to the plaintiff for inspection is extended for a further period of 2 weeks from date. Full stop. The defendant is also directed to file the affidavit of document within a week thereafter. Full stop. The defendant is also directed to exchange the suggested issues. List the matter on 28th of March 2025 for framing of issues.
Your Lordship, perhaps one small correction subject to your Lordship. Your Lordship, we had provided them with the affidavit of documents, but I must submit that no document was supplied along with it.
No document was supplied?
Yes, Your Lordship. Hence, because your Lordship recorded that I had disclosed the documents, so no document was supplied. We had forwarded the affidavit of documents. At the beginning, your Lordship had dictated.
Supreme suffering for the plaintiff, suffering for the defendant, counsel for the plaintiff submit that has disclosed. Now, plaintiff has forwarded the affidavit of supplied the affidavit of document to the defendant. Okay.
Great.
Yes, next.
For the defendant, my lord. And for the plaintiff, by your lordship's last order dated 8th of January, your lordship was pleased to condone the delay for lodging the affidavit in support of the caveat. It has been renumbered into TS 3 of 2025. Lordship would just be kind enough to pass the necessary directions for carrying out inspection discovery, if any, and
the issues are yet to be
issues,
framed, my
if
lord.
we can read the
Any
suggested
of
issues.
will perhaps have to be done.
Testamentary number lag gaya?
3 of 2025.
Yes.
Lordship.
So,
Lordship,
discovery.
Inspection discovery, and then if on the returnable date we can file a suggestive issues.
So appearing for the plaintiff, so appearing for the defendant. Parties are directed to complete the discovery and inspection of document within 2 weeks.
2 weeks, Your Lordship.
Within 2 weeks, full stop. Affidavit of document be filed within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 4th April 2025 for framing of issues. Next.
Grateful to you.
My lord, in this matter, I am appearing in behalf of the petitioner, my lord. I made an application for amendment of the probate application, my lord.
Amendment of the
probate application, my lord. My lord,
what amendment you ask for?
My lord,
what is the stage of the probate application? Notice issued. Caveat.
Already. Special citation already issued. Return back, left. Then made an application for amendment of the address.
Address of the.
Yes, my lord.
What is that? Where
My lord, kindly see the page 12. The portion we have marked the
flat number 1806,
yes,
building 4, Sapphire Island.
Deleted and new address already there. I have also the
Mumbai.
Aadhaar card of the Xerox copy of the Aadhaar card, page 8, my lord. Can you see the page 8? Sahayak Sahu, the address is there.
Sahayak Sahu.
Yes, my lord. Prayer in terms of prayer.
So appearing for the petitioner. The petitioner has filed a present application being GA1 of 2025, praying for amendment in the PLA application and probate application for addition of, for deleting the earlier address of one of the legal heirs of the testator and to incorporate the new address of the legal heir of the testator, namely Sahayak Sahu, S-A-Y-A-X Sahu. Consider the submission made by the counsel for the petitioner. Peruse the amendment as sought for by the petitioner. This court finds that the amendment as sought for by the petitioner is formal in nature and will not change the nature and character of the application. Accordingly, prayer A to D
Grateful.
of the master summon is allowed. GA1 is disposed of.
Grateful.
Next.
May it please your lordship,
Yes.
one of the properties is situated outside the jurisdiction of this honorable court, my lord. Therefore,
This court or this state?
My lord, this state, my lord, this state. My lord, we'll find at page 11, my lord, of the application, page 11, immovable properties, serial number B, my lord. This is a part of the affidavit of assets, my lord.
Odisha?
Odisha, my lord. Koratpur, Odisha.
Koraput, Odisha.
Yes. Yes.
283.
283, 3, my lord. Dispensing with prayers in terms of prayer A and B, my lord, of the master summons. Prayer A, my lord, we have sought leave.
So-and-so appearing for the petitioner. Police. Petitioner has filed the present application for issuance of citation under section 283 within bracket 3 of the Indian Succession Act on the ground that one of the immovable property as mentioned in clause 3, serial number 3 within bracket small b of the affidavit of asset, the property is situated at Jaipur, G-E-J-A-Y-P-O-R-E, district Koraput, Orissa 764001. Consider the submission made by the counsel for the petitioner, peruse the affidavit of assets and the schedule of affidavit of asset. This court find that the one of the property is situated outside the state of West Bengal. Accordingly, prayer A and B of the master summon is allowed. J1 is disposed of. Next.
And for the caveator.
That's my application for discharge of caveat,
affidavit.
I would
kindly take the affidavit once, in the supplementary affidavit, I have forgot to annex the affidavit, in the petition, in supplementary affidavit I have, they themselves say they are not the legal heirs, of the deceased. May I say,
They are?
Not the legal heirs of the
not
deceased.
the legal heir.
The caveat was, kindly takes page 30 of the application first,
GA1.
GA1,
You are for the petitioner.
Yes, petition, This is the family tree. The Rajat Kumar Basu is the deceased, He,
yes, Rajat
died, without any son or daughter. He was not married,
He was unmarried.
Unmarried,
Correct.
He had, 5, 6, 7, 8, 9, 10. 10, brothers and sisters, step brothers and sisters, and brothers and sisters even,
Rajat Kumar Basu.
Now,
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
All.
Yes.
Now, Himanshu.
Yes, what do you want?
Himanshu Bose.
Let him finish it.
Okay.
Himanshu Bose, to the left hand side, he is one of the brothers of the deceased,
Who is the petitioner here?
The petitioner is
Devjiban
Basu,
Devjiban.
And his son Anirban Basu. He is not Devjiban Basu,
one of the brother.
One of the brothers,
Correct.
Now, Himanshu Bose died on February 29, 2000.
Who is the caveator?
The caveator is the son of Himanshu Bose.
Son of Himanshu.
Right.
Okay.
So, the Himanshu Bose died on February 29, 2004.
Correct.
That is prior to after the death of
Before the death of Rajat
prior to the death of I just forgot the name, prior to the death of the deceased, So, my lord, after his death, my lord, his legal heirs, my lord, cannot come, my lord, as a legal heir of the deceased anymore. Because when his other brothers and sisters are alive, in the class 2 of the, my lord, the Hindu Succession Act, my lord, kindly, my lord, takes the Hindu Succession Act once. Take a look.
Section 15.
Yes, my lord. Section 15 and, my lord, the show, my lord, the...
Give the Indian Succession Act.
My lord, the Hindu law, my lord, Hindu Succession Act once, my lord. May I hand over, my lord? May I hand over?
Yes. Which section you are referring? Succession?
Yeah, no, Hindu Succession, my lord.
Succession Act.
Class section 8, my lord, first, my lord.
Yes.
My lord, the firstly, upon the legal heirs with the representative class 1. Secondly, if there is no legal in class 1, upon the heirs being relatives specified in class 2 of the schedule, my lord.
Section 8. General
Section
rule
8.
of succession. The property of the male Hindu dying intestate shall devolve upon firstly upon the heirs
of class 1, my lord.
The relative being the heirs being the relative specified in class 1. So admittedly there is no class 1 here.
No, admittedly no class 1, my lord.
No wife, no son, no daughter, no mother, no father.
My lord.
Yes, then.
My lord, class 2, my lord, may I show, my lord, the class 1, my lord?
Secondly, if
the
there
schedule.
is no legal heirs of class 1, then upon the heirs being the relative specified in class 2. Yes, class 2 where is defined?
In the class 2, my lord, can you take the schedule, my lord? The schedule, my lord, in the deed, my lord, the schedule, my lord. It is...
Where?
Section, the schedule will be at page 89, my lord. I don't know, my lord, which book, my lord. May I hand over, my lord, the... Should be there after... Some of the books has after section 8, some of the books has...
But it is... I don't
think... my lord. After 31, my lord, the repeal clause, some of the... my lord.
Schedule, yes.
My lord, class 1, my lord, class 2, father.
Class 1, father.
No, class 1, the son, daughter, my lord,
Yes,
goes
son,
away, my lord.
daughter, yes.
Class 2, father, my lord, he died much prior, my lord. Sons cannot be son's daughter or son's, my lord.
Son's daughter, then...
II cannot come into picture. My lord, II 2, 3, my lord, brother and sisters.
No. Class 2, 1 has gone, father is predeceased.
Yes. II
Correct.
1
then
is cannot be possible, my lord.
Class 2, 1 and 2 gone.
Cannot be possible.
Son
Then
and
3.
daughter, there is no son. 3 is the brother.
Brothers and sisters, my lord. Both get it, my lord.
Brother, sister.
Now, my lord, can you please check section 9, my lord, once, my lord, thereafter?
Order of succession of the heirs of the schedule among the heirs is specified schedule.
Those class 1 take simultaneously. First entry in class 1 shall be preferred to those in second entry. Those in second entry shall be preferred to those of the third entry.
Those in the second entry shall be preferred to those of the third entry and so on the succession.
So it satisfies 2 entry, then the third does not get it.
Third will come.
So, and the brother's son will be coming in 4. My lord. In the schedule, my lord, can you, my lord, takes, my lord?
Brother's son.
IV.
Brother's son. Correct.
Right. So therefore, my lord, if 2 is getting satisfied, my lord, the son of a predeceased brother shall not have the right, my lord, because when the time of the devolve starts after his
the
death
of the testator.
So, my lord, therefore,
at
my lord,
the time of testator, this brother was not there.
Not there. Admittedly,
So,
not
and
there.
other brothers are there.
Other
So
brothers are there, my lord. They have given the consent, my lord.
negative interest. So then the 4 will not come.
Other brothers have given the contest. And also, my lord, in their affidavit in support, my lord, can you, my lord, take the supplementary affidavit which I have annexed, my lord? My lord, 2 paragraphs. My lord, paragraph 7 once, which how they describe themselves.
Supplementary affidavit.
I have filed a supplementary affidavit, my lord, because, my lord, I had forgotten to annex the affidavit in support of Caveator, my lord.
Where it is?
My lord, I just now filed, my lord.
Devjivan Basu.
November 29th,
11th February.
Not November. I'm sorry, my lord.
11th
11th February. 11th February, my lord.
Yes.
Now, kindly, my lord, takes page 12, the internal, page 13, internal, page 3, page 13, my lord, page 13. Paragraph 7. How they describe themselves as a legal heir. I state that the deceased was not married and did not have any son and daughter. As such, I am the legal heir of the deceased above named. That my father, late Himanshu Bose, was the eldest own brother of the deceased.
Correct.
Now, my lord,
this is a caveat.
It's a affidavit in support of caveat, my lord.
Okay.
Now, my lord, thereafter, my lord, paragraph, page 17. Sorry, page 18, my lord. Page 18, my lord. Page 18, paragraph 17. In the middle portion, last 6 lines, my lord. It is stated that the petitioner propounder may not be the legatee of the last will of the deceased, but however are the close connected legatees mentioned in the last will of the deceased. Not thereafter, thus is the evidence that the deceased during his lifetime could not give his estate to his step nephews and deprive the other legal heirs into his own nephew, and it is highly suspicious the properties were not equally distributed. That is what his stand is, my lord. There is no stand to state that he has a caveatable interest, my lord. He has an interest to file a caveat, my lord. Not only a person, my lord, who is a legal heir will have the right, my lord, to contest a legal caveat. Or, my lord, he has a prior will. If I understood, my lord, he is not a legal heir. He has a prior will which gives him the right. But however, my lord, here, my lord, he claims to be a legal heir, but my lord, he has his father was predeceased, the deceased, my lord. Hence, my lord, he doesn't have a right, my lord, as such, my lord, in Hindu law, my lord.
That's all.
Good.
Yes, sir.
Firstly, I'll not shy away from merits, but I have a technical point which I will urge first. Thereafter, I'll go into the merits of the case. In fact, I have specifically disputed the family tree relied upon by the petitioner, and I have given a separate family tree in support of my caveat. That is there, but I'll just take up the preliminary point first. I will kindly come to prayer D of the master summons for once, my lord, because this caveat.
Prayer D of master summons.
Prayer D of master summons. And my lord will kindly see the date of the master summons and prayer D. And it is my specific case that this petition could not have been filed because this is out of limitation.
Yes.
Order dated November 13, 2024 be recalled. This is the prayer. This is the order by which I was allowed to file a caveat. They have
treated as non-contingent. Yes.
They have asked. They have prayed for recall.
What you want?
But this was filed on 31st January 2025. So
where from your readings, sir?
But will kindly come to the master summons, my lord.
Yes, master summons. I am there.
Master summons, page 2 of the master summons, my lord. Prayer D.
Page 2 of the master summons.
Prayer D, my lord.
Prayer D.
Order dated November 13, 2024 be recalled. And my lord will kindly see the date of the master summons. At the bottom of the page, my lord. 31st January 2025. So it is my specific case that when it comes to recalling of the order, the limitation is 30 days. This has been filed beyond 30 days, admittedly been filed beyond 30 days. There's no prayer for condonation of delay. On this ground itself, the application is cannot be entertained further. If I cannot satisfy on this ground, I'll go into the merits. And my lord, if my lord kindly sees the other prayers, they are all dependent on prayer D. Because prayer D, my lord, is the order by which I was allowed to file the affidavit in support of caveat. They are effectively asking for recalling of that order, and they are out of limitation. So they could not have prayed.
Where is the 13th order? Where is the 13th November order?
My
13 November order, my lord. It's annexed.
It's annexed, my lord.
The 37 of my application, my lord. My application, GA1.
To be mentioned, counsel for the Caveator submitted after mentioning the matter only yesterday, 12 November, the copy of the application along with the document sort of and counsel for the Caveator prays for time to file affidavit support of Caveator. Let the affidavit be filed within a week from date. Yes.
Yes, I have filed within a week where they have been served. Thereafter, they did not come up even after 1 month. So my lord, today after.
See, It's okay. They have asked for the recalling of the order. But you see, all then where is the discharge?
It's an application of discharge.
Finally, come to the prayer A. Prayer A.
That
The caveat
is
filed
the, for which I have said that I'm not shying away from merits, but this is the
No,
technical.
why I am telling you. See, court has granted you leave to file the caveat. Correct. You file the caveat. Now their cause of action arose. They find that in the caveat filed by you you are not having the caveatable interest. So they have a free to liberty to file.
As my deems fit. But this is a technical point. I was
next,
that
on the-
on
merit.
merits. I will kindly come to page 23 of their supplementary affidavit. This is part of my affidavit in support of Caveator. It is my specific case that they are not even legal heirs of this person.
23.
23.
Yes.
My lord, my lord will kindly see at the top Indu Bhushan Bose. This is the actual owner of the estate.
Indu Bhushan Bose is the father of the Rajat Kumar.
My lord.
Basu.
My lord. Father of Rajat Kumar Basu is Indu Bhushan Bose.
Is a Bose or Basu?
Bose, Basu are not same, my lord.
Bose and
Sometimes
Basu.
Basu summarizes it, Bose, my lord.
Yes.
My lord, he has two wives. One is Bina Bose and the other is Chobi Bose. When it comes to Rajat Kumar Basu or my clients, they are all sons of Bina Bose and Indu Bhushan. They are from the branch of
from the Indu Bhushan and in Bina.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9. 9 sons. Himanshu, Nirmal, Rajat, Subrato, Dipali. 1, 2, 3, 4,
2, 3, 4,
5,
5, 6,
6,
7, 8.
6.
4 sons, 3 daughters, my lord. No, the first son is Himanshu Bose.
First is Himanshu, yes.
Himanshu Bose, that is my predecessor in interest.
Correct.
Second is Nirmal Kumar Bose.
Yes.
Third daughter is Ranu Ghosh.
Ramu is the third. Ramu, third, yes.
Fourth son is Rajat Kumar Basu, who's
Fourth is
the will of Rajat Kumar Basu is in
Correct.
question.
Four
The
Rajat.
fourth son is Shubroto Basu.
This is the fifth.
The sixth daughter is Deepali Dotto.
Dipali Datta, 6 years.
The sixth daughter is Choitali Ghosh. And the seventh daughter is Meera Ghosh.
Chetali will be 7.
I'm sorry, seventh.
Chetali will be 7. Then Meera.
Then Meera. Meera Ghosh.
8. Total 8. Total 8.
My lord. Total.
As per petitioner's case.
Petitioner's case is that
1,
they
2,
are
3, 4, 5, 6, 7, 8, 9, 10. 10.
These are completely different. The petitioner's mother and my mother and Rajat Kumar Basu's mother are different.
So
they
trying to say, my lord.
So they cannot be said that it is his own brother at all. Rajat Kumar Basu's brother is not Devjivan Basu because the mother is different.
Brother.
So Hindu Bhushan and Bina Bose.
My lord.
Out of the wedlock, Himanshu. You are one of the legal heirs of the Himanshu.
My lord.
Correct. Nirmal is not in picture here. Correct. Then the daughter Ranu.
Not
correct. She is not in picture.
No.
Rajat Kumar Basu.
It is his will.
Who is the testator?
My lord.
Who is the testator?
My lord.
Rajat is a testator. So he is the son of Bina and Indu.
My lord.
Correct. Then Subrata.
My lord.
He is not in picture. Then come to Dipali. Then Chaitali. Then
Meera Ghosh.
These are the 1, 2, 3, 4, 5, 6, 7, 8.
Right.
These are 8. Right. Correct. And second marriage from the Chavi.
Right.
From the Chavi, Devjivan.
They are my learned friend's client.
Executive, my lord.
Okay. Devjivan
Bose, Kollan Basu, Mandira Guho Thakurta.
Mandira.
These are my learned friend's client.
So they are the sons of
Chobi Bose.
Second wife.
Second wife.
Okay.
Second wife. So the branch is not one and the same. The branch when it comes
But the property belongs to Bina or Chabi or Indu.
The property belongs to Indu Bhushan Bose.
Then if the property belongs to Indu Bhushan Board, mother, nothing. If it is the will of Bina Bose, then your argument can sustain.
But
if
it is
the property of Indu Bhushan, your argument cannot be sustained.
Deeply obliged. The only thing is that today the will is not of Indu Bhushan Bose. The will is of Rajat Kumar Basu.
Maybe, but the property belongs to whom? It is the Rajat Kumar Basu's own property, or it is the inherited property.
But inherited may have been inherited, but this property exclusively belongs to Rajat Kumar Basu. None of the properties which are allegedly bequeathed. I am disputing the will itself. That is a different thing. But when it comes to the properties bequeathed by the will of Rajat Kumar Basu, it exclusively belongs to Rajat Kumar Basu as on the date of execution of the will, if the will is there at all. I'm not admitting the existence of the will, but if it belongs to Rajat Kumar Basu as on the date of his death, today Rajat Kumar Basu and Devjivan Basu are not directly connected to each other.
Why?
Because the mother is different.
Mother is different, but father is same.
Father may be same. Father may be same, but the mother is different.
Maybe. It is not. That's why I'm asking. If it is the property of the Chabi, then you can say the Rajat cannot be.
If it is
the property of Bina, then this Devjan will not come.
My lord, I have explained in page 5, paragraph 7. It is from the PLA, my lord, from this honorable court's order, my lord, I have got the properties. It's from Indu Bhushan's properties, my lord, I have got it.
Then
explain that.
Where is that?
Page. And in the PLA, my lord, the application also, my lord, is there. My lord, kindly, my lord, takes the PLA.
Yes. Page number.
Page 5, paragraph 7, my lord. It's pertinent to mention that the properties and assets of the deceased are named as self-acquired and some are inherited from his father, Indu Bhushan Bose, and like Indu Bhushan Basu. Since deceased by virtue of the last will and testamentary date such and such, which was duly probated by the Honorable High Court from his uncle Shanti Bhushan Basu, alias Shanti Bhushan Bose, since deceased by virtue of the last will and testamentary date, which was duly probated by this Honorable Court in PLA and such and such. And some are inherited from his brother Nirmal Kumar Bose, alias which was duly probated before this Honorable Court on 22nd December 2015.
Yes. Right. May I just draw your lordship's attention to section 18 of the Hindu Succession Act for once? This is the provision which differentiates between full blood and half blood. This says heirs related to an intestate by full blood shall be preferred to heirs related by half blood. So my lord, when I am a full-blooded heir and they are at best an half-blooded heir, nothing else. So I have to be given preference over the half-blooded heir.
He has to qualify as an heir first.
Today I was served a caveat. The fact that I have caveatable interest has been admitted by my learned friend's client. That is the reason why I was served a citation. Otherwise, I would not have.
He filed at caveat much prior. That's the reason, and I have to file. I have to give him a citation. He had filed a caveat in 2022, much prior to my filing of the PLA, my lord.
Yes.
In my humble submission, the rights of a half blood cannot be as good as that of a full blood. I am admittedly a full-blooded branch, I come from the full-blooded branch of the deceased. I am the brother's son. This is an admitted fact, and he is a step-brother's son. So when it comes to a brother's son, he will quite naturally have more preference over the rights of a person who is a step-brother, which is Section 18 of the Act, my lord.
I don't think this is applicable. No law is applicable.
Heirs related to the intestate by full blood shall be preferred the heirs of the by the half blood. So how you can be now after the death of whether you will be a full blood after the death of your father?
Lord, I'm a lord. Lord, here, my lord.
Your father died. Your father was
My father has died. Father has died.
Then?
My father may have died, but
either father died, then
That will come there, not here.
give me a moment. Scheduled.
come ready with all these things. So-and-so appearing for the petitioner, so-and-so appearing for the caveator. Police petitioner has filed an application being J1 of 2025, praying for discharge of caveat. Police counsel for the respective parties argued at length, but due to paucity of time, hearing could not be completed. According case is adjourned. Let the matter appear on 7th March 2022.
Grateful, my lord.
My lord, item number 72, my lord. Very short matter, only for publication.
Name the top of the list, my lord, on 7th, my lord.
Yes, it will come.
Next, my lord.
Yes.
72, my lord. Only
Come
for
tomorrow,
publication.
yes.
Only for
Regarding item number 101, my lord, is similar, 71, my lord. It is similar to 69, my lord. The property is situated in Delhi, my lord, and
Come on the next.
Your Lordship, before Your Lordship rises, Your Lordship, the special citation was issued on 29 January. Your Lordship, there has been a delay of 2 days in lodging the caveat if the leave may be granted, Your Lordship. Your Lordship, can I come on Monday?
Come with an application. Come with an application. Leave
Oh,
for caveat cannot be granted orally.
I shall come. Your Lordship, grateful.
come on to, my lord, another aspect of the matter. My lord, one of the arguments, my lord, advanced by my learned friends that the letter of the APL on the basis of which, my lord, the circular resolution of 16th April 2021, my lord, was passed, was in violation of the order of, my lord, September 2020, 18 September 2020, and, my lord, as clarified on 1st of October 2020. Therefore, my lord, the removal is bad. And, my lord, on the same basis, my lord, it says that, my lord, 16th April 2020, my lord, resolution is in violation of the order dated 18 September 2020, as clarified on the 1st of October. Now, my lord, with the greatest of respect, my lord, this argument really, my lord, has no basis. Now, my lord, kindly, I have, my lord, these are all on record. My lord, I've prepared, my lord, a compilation of the orders, my lord, which were relied on, so that your lordship doesn't. Shop. My lord, kindly take, my lord, here, my lord, there are six orders.
Yes.
My lord, I won't trouble your lordships with 23rd August, my lord, order. Kindly come to, my lord, the 18 September order, which starts, my lord, at page 37 of the compilation. My lord, this is also, my lord, reported in 2020 SCC Online, Cal 1671.
Yes.
My lord, kindly come straight away, my lord, to, my lord, paragraph, my lord, 212, which is at page 95, my lord, of the compilation.
Yes.
However, upon consideration of the fact of the case in detail, apprehended injury pleaded in the petition, and other materials available on record, submissions made by the counsels for the parties, the apprehended damage at the instance of the plaintiffs with the leadership of plaintiff number 1, in absence of any interim order, prima facie case made out in the application, balance of convenience and inconvenience vis-a-vis the apprehended injury which might be suffered by the ultimate beneficiaries of the estate of the deceased. This court is of the view that the defendant petitioners have made out sufficient case to get an interim order / temporary injunction to preserve and protect the interest of the ultimate beneficiaries under the will of PDB concerning the estate of the deceased, and this court, in aid of the final relief in the testamentary suit, in exercise of powers conferred under 247 of the Indian Succession Act, passes the following orders. Now, my lord, there are three directions, A, B, and C. May I, my lord, place A? The plaintiff shall implement the decision dated 19 July 2019 and 30th July 2019 of the APL committee taken by majority, as also all consequential decisions of the APL in furtherance of the said decisions, and shall be restrained from drawing any benefit personally from out of the assets of the estate of the deceased during the pendency of the testamentary suit. So, my lord, there was a direction that you implement these decisions, and, my lord, all consequential decisions in furtherance, and, my lord, then restrain from drawing any benefit personally out of the assets of the estate. Then B, plaintiffs are also restrained. Plaintiff, my lord, is, my lord, H.V. Lodha, my lord, amongst, my lord, many others, are also restrained from interfering with the decisions of the APL, and any decision, kindly note this, which might be taken by it in future by majority, if the same directly or indirectly relates to the estate of the deceased. And further, the plaintiff number 1, Harshvardhan Lodha, is restrained from holding any office in any of the entities of MP Birla Group during pendency of the suit. Then C, my lord, kindly note C also. Defendants are also restrained by an order of temporary injunction
from interfering with the APL's decision by majority during pendency of the suit. So, my lord, any decision taken by APL, my lord, during the pendency, my lord, they are, my lord, restrained. Now, my lord, an appeal, my lord, is preferred. Kindly come to, my lord, the 1st October 2020, my lord, order. Now, my lord, kindly, my lord, I'm not troubling your lordships, my lord, with, my lord, the submissions and the various cases cited. Kindly come straight away, my lord, to paragraph 18 at page 110, which is internal page 13. My lord, of, my lord, the compilation, 110.
Page 100.
10 of the compilation, page internal page 13, my lord, of the order. 1st October, my lord, starts at page 98.
Yes.
And my lord at 110, which is, my lord, internal page.
Yes.
My lord, kindly take, my lord, para 18, my lord, last, my lord, 8 lines. My lord, sentence starting the power of the probate court. The power of the probate court under section 247 of the Succession Act necessarily includes the power to regulate and permit such shares which are in the domain of the commercial activity to be utilized to generate appropriate income and to better utilize the same in the best interest of the affairs of the estate of PDB. Now, my lord, kindly see, which would ultimately reflect on the end beneficiaries. Now, who are the end beneficiaries? Which includes charitable trust, educational institutions, and such other activities.
Yes.
So, my lord, it recognizes that, my lord, the shares, my lord, which, my lord, the end beneficiaries are the holders of the shares, which are, my lord, charitable trust, educational institutions, and such other
activities. Yes.
So, my lord, what is important is to, my lord, recognize, my lord, that the division bench itself recognizes, my lord, at that time on 1st of October, my lord, 2020, that, my lord, the shares held by the trusts and educational institutions, my lord, are, my lord, part of the estate. Now, my lord, we have studied the impugned order issued by the probate court in the backdrop of the quality and extent of jurisdiction available under section 247 of the Succession Act. We have bestowed our anxious consideration on the basis of the fundamental issues at this stage as to whether the said order is to be stayed at this stage till the final disposal of the stay applications and the appeals. We see that the impugned order refers to material facts, reflects reasons, and demonstrates judicial consideration and determination of matters which fall within the domain of section 247. We cannot treat it as a perverse decision or one which deflects the course of justice, or that it is not in the best interests of PDB's estate. On the basis of various materials on record, to which we may not make any copious reference now, we notice that there are different orders inter partes, which tend to indicate that this matter requires further consideration without any interlocutory order staying the operation of the impugned order. We are also of the view that the power of the APL committee, APLC's APL committee, to consider and administer the estate of PDB is repeatedly asserted through the different judicial orders of the probate court, the division bench of this court, as well as the Honorable Supreme Court of India. Now, kindly mark this. We therefore do not find any reason to issue any stay as sought for at this stage. Now, my lord, kindly see, which is, now, my lord, para 18 and 19, my lord, in my respectful submission, my lord, shows, 1, no stay is being granted. 2, my lord, that, my lord, the shares held, my lord, by the trust are treated as, my lord, part of the estate. Now, my lord, kindly see the clarification. We may, however, clarify that the word implement occurring in paragraph 8 among the 3 directions issued by the learned judge means abide by. So, my lord, at page 95, A means, my lord, abide by. Instead of implement, abide by.
Yes.
My lord, the language is toned down. My lord, that's all. It is further clarified that the operation of paragraph B among the directions would be what? a restriction on plaintiff number 1, Harshvardhan Lodha, to the extent of it being a restriction from holding any office in any of the entities of the MP Birla Group during the pendency of the suit on the strength of the shares referable to the estate of PDB. Now, my lord, a society, my lord, if he's holding a position there, my lord, it is, my lord, our respectful submission is this clarification related to, my lord, position held by him, my lord, in companies, because otherwise shares, my lord, are irrelevant, considering, my lord, what paragraph 18 says.
Office in any of the entities of the MP Birla during the
pendency of the suit on the strength of shares referable to the estate.
shares in the company.
So, my lord, this clarification pertains to holding of office in a company. It has no application, my lord, to, my lord, the other entities which are charitable trusts, educational institutions, my lord, which are the societies, my lord, at all. Because, my lord, 18 recognizes, my lord, at that stage, and I'll show, my lord, even the contempt, my lord, this is what the court has recognized. Then, my lord, kindly come to para 21. We hasten to add that since we are keeping open all issues for further consideration and are only proceeding to decide as to whether an ad interim order is to be issued, we are not dealing with the judicial precedents referred to by the learned advocates for the appellants, though it is not as if we are not bearing in mind the fundamental principles brought in through those precedents referable to the realm of testamentary jurisdiction and company law. Now kindly see the end result. In the result, the prayer for ad interim stay of the judgment and order impugned dated so-and-so is declined. So, my lord, the order has full force. But, my lord, the two, my lord, directions which are issued, instead of implement, it is abide by. It still means, my lord, comply. My lord, then it says, my lord, clause C, my lord, is, my lord, defendants are restrained from interfering with APL's decision. That has not been touched at all. And the clarification given to, my lord, B is, my lord, where a position is held, my lord, where, my lord, shareholding rights are relevant. That is, my lord, only, my lord, with regard to companies and, my lord, not societies. So, my lord, even if this order, my lord, were binding, my lord, on, my lord, first, my lord, there is no violation, therefore, my lord, of the order by the APLs writing these letters. Second, my lord, even, my lord, if, my lord, this order were to apply to the APLs, my lord, it cannot apply to the society, because societies are not parties to this at all. They are not parties to this. And I'll show, my lord, that it has expressly been made clear. In fact, this prayer was sought in the appeal relating to societies, which was not allowed. I'll show that portion.
That prayer was there?
Yes, yes, my lord, I'm coming slowly. Now, my lord, I am, my lord, first up to, my lord, 18 September 2020 and 1st October 2020. My lord, there is no violation, my lord, according to us. Now, my lord, what comes, my lord, next, my lord, in the series? No. Now, my lord, kindly have a look, my lord, at the resolution of 16th April 2020 or 2021. My lord, this is, my lord, in CS 16, volume 2, page 171. GA1. CS 16, my lord, page 171.
Yes.
My lord, kindly take, my lord, at the top. The society is in receipt of various communications dated 12th November 2020.
Page 70.
171, my lord. 171.
Yes, society is in receipt.
The society is in receipt of various communications dated 12th November 2020 and 27th February 2021 from the office of the joint administrators of the estate of Srimati Priyamvada Devi Birla, copies of which are enclosed. Then, my lord, it gives the history, my lord, of my lord, the litigations, and my lord goes right up to my lord, the fourth paragraph, by a set of judgments and orders, including the judgment and order dated 23rd August, copy attached, passed by a division bench of the Honorable, a 3-member committee was appointed as administrators pendente lite for the purpose of so-and-so to exercise rights and powers of general administrators over the estate other than the right of it. The APL committee presently comprises of, my lord, that is given. Then, my lord, on 2nd November 2020, the society received a communication from Khaitan Company, advocates for the defendants, enclosing the following decisions, judgment, copy attached. So, my lord, there's a letter, my lord, from, my lord, the advocates, my lord, of, my lord, the defendant in the suit. Then, my lord, letter dated 12th December received by the society from the APL committee, copy contains judgment and order dated so-and-so and the order dated so-and-so of the division bench, passed in the matter of probate proceedings. The letter dated 27 February 21 received informed that the APL committee at its meeting held on 26 February has decided by majority to nominate the following persons for being appointed as trustees, member of governing council for a period of 3 years from date of appointment. So-and-so. Consent letters, APL committee in the above letter dated 27 February 2021 has also stated that the existing trustees do not include Harshvardhan Lodha anymore on account of the judgment dated 18 September 2020, read with the order dated so-and-so of the Honorable Calcutta High Court. Then, my lord, 2 societies. My lord, this is over and above what the APL said. Now, my lord, what happens? My lord, there's a reliance on other material. 2 societies, namely MP Birla Netralaya and MP Birla Medical Research Center, both part of the MP Birla group, with similar facts in this case, have in the meantime obtained opinion on this matter from Justice Ashok Kumar Ganguly, former judge, on the following: whether Mr. Harshvardhan Lodha ceases to hold office of trustee and chairman in the above societies, consequent to conjoint reading of the orders dated so-and-so and first, read with the memorandum of association and rules and regulations of the society, and 2, whether in view of the aforesaid 2 orders, read with the memorandum of association and rules and regulations of the societies, the trustees of the societies are obliged to implement and act upon the directions of so-and-so for appointment of certain individuals as contained in their letters, more particularly when these societies do not hold any shares in any of the companies of the MP Birla Group. The opinion of Justice so-and-so on the above 2 queries is in the affirmative. A copy of the opinion is enclosed. So that is also provided for decision-making process. Copy of the memorandum of association and rules and regulations of the society is also included. In view of the above, your consent is hereby sought on the following resolutions, which are intended to be passed by circulation. Resolved that the cessation of Sri Harshvardhan Lodha as trustee and president and member of the governing council of the society, consequent to the judgment dated so-and-so of the Honorable Single Judge of Calcutta High Court and order dated so-and-so passed in the matter in respect of estate as communicated by the office of so-and-so, by letters dated so-and-so, be and is hereby noted. Now, my lord, the next is very important. This is and confirmed and taken on record. This is, my lord, the independent decision-making, my lord, by, my lord, the society. Then kindly turn over. Resolved further that as requested by the office of the joint administrator so-and-so by their letter dated so-and-so and in terms of Article 48 and 10 of the rules and regulations of the society, so-and-so is appointed as trustee and member of the with immediate effect. And, my lord, then resolved further as requested by the office of joint administrator so-and-so, then in terms of Article so-and-so, R.S. Thakur BN is hereby appointed. Kindly accord your approval to the aforesaid proposed by affixing your signature in the space provided and sending the same back.
Yes.
So, my lord, my respectful submission, my lord, this clearly shows that, my lord, there is an independent decision being taken. Second, my lord, it is on the basis, my lord, there are letters, over and above letters from APL, my lord, there is, my lord, and my lord, the memorandum and, my lord, the regulations of the society have been considered. And, my lord, an opinion, a legal opinion, my lord, has also been, and this is, my lord, a resolution, my lord, based on that. Now, my lord, what happens? My lord, in between, and this order, my lord, is not in this compilation, but they've relied on it. My lord, they handed up a copy. I don't know if your lordship has that. Otherwise, my lord, in the contempt, my lord, in the contempt proceedings, which was instituted, my lord, by, my lord, the defendants in, my lord, the testamentary suit. It's a judgment of 22nd April 2021. My lord, if it's not there, I have a copy, my lord.
22nd May?
April 2021. My lord, it's a division bench. My lord, they'd given it up separately, my lord. In case it's not there, I have a copy, my lord.
Okay, you give. Yes.
My lord. Kindly see, my lord, paragraph 8.
Paragraph
8, my lord, which is, my lord, in what the copy I've handed up, my lord, page 7.
Yes.
My lord, paragraph just above 8, my lord, CC 38 of contempt against. The summary of the allegations are inter alia as follows. HVL continued to hold office as director chairman in, my lord, these are all, my lord, companies. And it's directorship of companies. What I'm pointing out to your lordships is, my lord, there is, my lord, no allegation with regard to, my lord, trustees or, my lord, governing council member of, my lord, societies. HVL participated in the meetings of board of directors of the above companies held on so-and-so, so-and-so, so-and-so as director chairman. Then, my lord, HVL failed to abide by the directions of the APL committee dated July 19, 2019, 30th July 2019, 23rd July 2020, and so, by which the APL committee decided not to support the reappointment of HVL. And, my lord, HVL failed to abide by directions of APL committee contained in letters dated 4th and 5th November 2020 issued to the board of directors of these companies. So, my lord, the act of contempt also, my lord, was restricted to, my lord, holding of position in, my lord, companies. It had nothing to do, my lord, with the trusts. Now, my lord, kindly come to now, my lord, kindly come to
44 and 47 of the APL edition.
Yeah. My lord, para 43.
Yes.
My lord, the two decisions, my lord, of, my lord, the APL committee. My lord, para 43, my lord, your lordships will find. This, my lord, relates to the companies. Para 44 is July 19, 2019,
Yes.
which was, my lord, prayer A, my lord, 212A, my lord, of, my lord, the learned single judge. And, my lord, 46 is, my lord, 30th July. My lord, para 47, my lord, is the decision, my lord, which are referred to.
Yes.
53. My lord, kindly, yes. Now, my lord, kindly come to, my lord, paragraph 53. My lord, just before that, my lord, I just want to show your lordships, my lord, para 50.
Yes.
The members of APL committee got their names recorded in respect of shares which were in the name of PDB as was disclosed in the inventory contained in the interim report prepared and submitted. They exercised their voting rights at the meetings held on so-and-so when HVL was so-and-so. The strength of voting of shareholders, AGM, are so-and-so. Now, my lord, kindly see Universal Cables, that's UCL, that's a company. Meeting is so-and-so. Total votes cast, 2,68,000 so-and-so. My lord, votes cast by public, non-promoters, non-promoter group so-and-so, 30,81,451. Total number of votes cast against appointment of HVL, including votes cast on the basis of shares of PDB, so-and-so. Then my lord, Birla Cable, so-and-so. The APL committee, as per its above decision, voted against such votes in respect were declared invalid, excluding the votes against HVL. HVL was reappointed director. We find that so-and-so implemented its decision A and voted against HVL so-and-so. Then, my lord, subsequent decisions, my lord, of APL, etc., were also not to support, etc. Now, my lord, kindly come to para 53.
Yes.
With regard to allegation of violation of prohibitory part, second part of the order from holding any office on the strength of shares referable to the estate, we find that going by the voting pattern, now kindly note this, it is a possible view that HVL could have been reappointed even on the strength of the shares not referable to the estate of PDB. That is personal shares of PDB and shares referable to the promoters, promoter group and persons acting in concern. So what is it saying? My lord, that it's a possible view that HVL, my lord, got appointed as a director without, my lord, the support of shares of PDB and, my lord, the promoters, promoter group and persons acting in concern. In all the AGMs, the shares which were in the name of PDB voted against reappointment of HVL. Voting figures have been filed, etc. Then, my lord, kindly come to para 55. Although the defendants all along contended the issue as to what comprised the estate of PDB had already been decided through different judicial orders of this court as well as and should not be reopened, it is possible that the extent of the estate of PDB with regard to controlling interest over other MP Birla Group companies would include shareholdings of promoter and promoter group and persons acting. And that includes the trusts. Then, my lord, however, HUL could have been reappointed even without the votes of the promoter groups and PSCs and only on votes of public shareholders. In such event, it is also possible that HVL did not continue to hold office only on the strength of the shares of PDB. HVL could also hold office excluding shares referable to the estate of PDB. Thus, the contempt has not been proved beyond reasonable doubt. So, because there's a possibility that, my lord, without, my lord, promoters shareholding and PDB personal shareholding, my lord, he could have, my lord, been otherwise appointed. My lord, therefore, we cannot say beyond reasonable doubt, my lord, that he has violated. That's the test, my lord, for contempt. And, my lord, kindly, my lord, when HVL could have been reappointed on the shares of public shareholders, invitation to HVL to participate was as per procedure. If HVL could be reappointed as a director on the strength of votes of public shareholding alone, as per voting figures, any deeper probe would not be proper at this stage. Contempt has to appear. So, my lord, the picture presented to court, my lord, was that, look, the public shareholders have voted, my lord, in more than, my lord, what is, my lord, shown to be, my lord, PDB shares or, my lord, promoter group shares. So, he could have been appointed. And on that basis, my lord, the contempt, my lord, was, my lord. So, my lord, with the greatest of respect, my lord, my lord, really, my lord, no, my lord, basis, my lord, for saying, my lord, just because contempt got dismissed, my lord, that, my lord, HVL is entitled to continue, my lord, as a trustee, my lord, of, my lord, or, my lord, there has been, my lord, a violation. Because first, my lord, 1st October clarification related to companies only, and, my lord, the contempt also relates to holding of a position, my lord, in a company. It has got nothing to do with holding of, my lord, a position, my lord, as trustee. Okay. Now, my lord, if there was seriously, my lord, any violation, my lord, there would have surely been a contempt, my lord, filed, my lord, of the order of 1st October 2020. My lord, HVL, my lord, came to know, my lord, my lord, even according to them, my lord, on 9th of December 2021, of the 16th April 2021 resolution. My lord, no steps taken. My lord, in my lord, the proceedings, my lord, before, my lord, the division bench also, which was, my lord, really the competent, my lord, court to decide, my lord, whether there was, my lord, a violation of the order or not. Now, my lord, kindly see what happens. Assuming, my lord, no, we'll come. Now, my lord, assuming, my lord, that, my lord, the act of removal of, my lord, HVL, my lord, as a trustee was pursuant to the order of the single bench dated 18 September and clarification dated 1st October. My lord, did, my lord, the order of, my lord, the division bench dated 14 December 2023 wipe that out so that, my lord, he stands reinstated. My lord, this is again, my lord, they have said he stands reinstated. Right. Kindly take, my lord, the decision, my lord, reported in, my lord, I'm citing, my lord, a case here. My lord, 2005, one Supreme Court cases, 754. Paragraph 41. 41 to 44. My lord, kindly take, my lord, paragraph 41. My lord. My lord, under the Representation of People's Act, my lord, conviction, my lord, disentitles, my lord, a person, my lord, to stand for elections. 2 years, my lord. Now, my lord, if, my lord, there is, my lord, the matter is carried on appeal, but on the date the nominations have to be filed, he's still, my lord, disqualified. Does, my lord, the appeal, my lord, success in the appeal, my lord, change the situation? My lord, court held no, it doesn't result in, my lord, yes.
Reverse.
Kindly, yes. Now, kindly see, my lord, para 41. My lord, the correct position of law is that nomination of a person, your lordship has that.
Yes,
my lord?
yes.
Disqualified within the meaning of subsection 3 of section 8 of the Representation of People Act on the date of scrutiny of nominations under section 36(2)(a) shall be liable to be rejected as invalid, and such decision of the returning officer cannot be held to be illegal or ignored merely because the conviction is set aside or so altered as to go out of the ambit of 8(3) consequent upon a decision of a subsequent date in a criminal appeal or revision. What is relevant for the purpose of section 8(3) is the actual period of imprisonment which any person convicted shall have to undergo or would have undergone subsequent upon the sentence of imprisonment pronounced by the court. And that has to be seen by reference to the date of scrutiny of nominations or date of election. All other factors are irrelevant. A person convicted may have filed an appeal. He may also have secured an order suspending execution of the sentence or the order appealed against under section 389 of the code. But that again would be of no consequence. A court of appeal is empowered under so-and-so pending an appeal by a convicted person, the execution of the sentence be suspended. Also, if it is in confinement, that he be released on bail or bond. What is suspended is not the conviction or sentence. It is only the execution of the sentence or order. It is suspended and not obliterated. It will be useful to refer to, in this context, to a constitution bench judgment of so-and-so. Convict had earned a remission and the period of imprisonment reduced by the period of remission would have had the effect of removing disqualification as the period of constitution bench held so-and-so. Then, my lord, kindly come to para 44. We are therefore of the opinion that an appellate judgment of a date subsequent to the date of nomination or election, as the case may be, and having a bearing on conviction of a candidate or sentence of imprisonment passed on him, would not have the effect of wiping out disqualification from a back date if a person consequent upon his conviction for any offense and sentenced to imprisonment for not less than 2 years was actually and as a fact disqualified from filing nomination. So, my lord, here, my lord, if, my lord, the decision has been taken, my lord, to, my lord, remove him, my lord, as a trustee, or, my lord, by virtue of, my lord, these two orders, my lord, he stands removed as a trustee. Merely because, my lord, of the division bench final disposal of the appeal, he doesn't get reinstated. The relevant, he has to challenge, my lord, I will show.
On the date of.
Correct, my lord, he has to challenge, my lord, that decision, that it's not good. Now, my lord, kindly come to, my lord, yes. Now, my lord, the important thing is,
Yes.
my lord, my lord, order, my lord, of 14th of December, 2023.
Yes.
My lord, kindly take that order. It's in this compilation, my lord, page 124. Compilation, my lord, page 124.
Yes.
My lord, kindly come to, my lord, page, my lord, where is, my lord, 146, my lord, bottom.
Yes.
My lord, one of, my lord, the appeals, my lord, which are filed here, my lord, is, my lord, by H. Harshvardhan Lodha, my lord. Kindly see item 4 at the bottom of page 196.
APO 92.
Yes, my lord. APO at 146 arising out of so-and-so. Kindly turn over the page 1 for appeal filed by Harshvardhan Lodha.
Yes.
Now, my lord, in this appeal, my lord, there were, my lord, several, my lord, applications. And what are relevant for the purposes, my lord, of, my lord, this case, my lord, are GA 3, 4, and 5. Kindly come to page 150.
GA 3 of 20.
GA 3, page 150, my lord, the prayers.
Yes.
Kindly see GA 3. Decision of the two members of the APL committee dated 8th October 2020 and any other similar decision be set aside. Injunction restraining the APL committee from giving any effect or further effect to the decisions of the two of the APL committee members dated 8th October 2020 or any other similar decision. If necessary, decisions and directions by way of communications orders of the said two members of APL committee more fully stated be declared illegal. Injunction restraining so-and-so from issuing any direction similar to those summarized in para 66. Injunction restraining from issuing similar to those in, so my lord, para 66, 68 and my lord 8th October or similar decision. My lord, I've given my lord production, my lord, of my lord these GAs. Lordship will kindly have a look at it. Then my lord GA 4. One. Then, my lord, kindly take prayer. Injunction restraining joint APLs from in any manner interfering, kindly note this, with the discharging, and this is filed in 2021, GA4.
Yes, GA4 in APO.
In his appeal, Harshvardhan Lodha's appeal, he has filed GFO, injunction restraining the joint APLs from in any manner interfering with the discharging of petitioner's functions and duties as trustee and or managing committee member of societies and trusts, particulars whereof are given in Annexure TT, which have no share capital, and the estate of Priyambada Devi Birla as per so and so, and union. Then, my lord, stay of the order dated 18 September and the direction which restrains the petitioner from holding any office in any of the entities of MP Birla Group, injunction restraining joint APLs from taking any decision or action in respect of any asset that does not form part of estate of so-and-so as per, and the unanimous. The decision of the two joint APLs held on 8th October, 23rd October 2020 be set aside. And, my lord, this goes up to, my lord, next prayer, 24th December, my lord, be set aside. And then, my lord, F, injunction restraining joint APLs and each of them from giving any effect or further effect to any of the impugned majority decisions taken at the meeting of the joint APL held on so-and-so, 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 or any other similar decision. And more particularly, the decisions to alter the composition of trustees and managing committee members of societies and trusts which have no share capital, where estate of so-and-so as well as unanimous has no legally enforceable right. Then again, injunction, etc., etc. And, my lord, kindly come to, my lord, page 154. Prayer M. All appointments, nominations of directors, trustees, and managing committee members at the behest of two joint APLs, more fully stated in para 61, be declared illegal, null and void.
Yes.
So, my lord, we have, my lord, GF4, and then, my lord, where's GF5?
GF5.
And, my lord, GF5 at, my lord, page 155.
Yes.
Directions dated 22nd so-and-so passed by two of the three APLs. Similar decisions be set aside. Stay of the order dated so-and-so, which holding any office during the pendency. Injunction restraining joint issuing any directions or communications in exercising any right in respect of shares. Withdraw all letters written, my lord, by them to etc. societies, trusts and the like when purporting to exercise rights not arising out of shares. Injunction restraining APLs from giving any further effect to so-and-so, from in any manner interfering with the management and affairs of companies, societies, trusts, or any entity not party. These were, my lord, the prayers. Now, my lord, TT at page 151 specifically includes, my lord, the society before your lordship, my lord, South Point.
Page 161.
151, my lord, there's an annexure TT in respect of which, my lord, injunction has been sought. Specifically refers to, my lord, I've given production, I'll come to it. My lord, kindly make a note. Now, my lord, these and, my lord, annexure S, my lord, which is referred to, my lord. Yeah. No, but annexure S is here, no, in which RS. Huh? Yes. Now, my lord, kindly come to, my lord, the issues. These were applications which were pending. At page, my lord, 350, so, my lord, my first submission is reliefs which are being sought here had in effect already been sought, my lord, before the division bench. Now, my lord, kindly come to page 350.
Yes.
Out of the labyrinth of arguments advanced, the following broad issues and sub-issues emanate for adjudication in the present case. Now, my lord, kindly come straight away to 3.
APL pendant network.
APL administrator pendente powers. Now, my lord, kindly see what the issues are. How far APL can interfere in company affairs. Then, my lord, whether APL decisions have to be unanimous or majority view prevails.
Yes.
So, my lord, there is nothing, my lord, concerning, my lord, societies and APL, which is, my lord, being, my lord, adjudicated here. Now, my lord, kindly come to, no, before that, 172. My lord, one paragraph, my lord, was relied on, my lord, by my learned friends. Para 172. 406, my lord. Hence, the testamentary court cannot pass orders directly in respect of the management and affairs of corporate contractual rights of other entities, including companies, trusts, etc. So it cannot, my lord, pass orders directly.
Yes.
And none of the courts have passed an order directly, including here. Now kindly come to the operative portion. 4, my lord. 1, 3, my lord, it starts. My lord, paragraph 200.
Yes.
Thus, the issues formulated above are answered as follows. My lord, kindly come to, my lord, 419, my lord, issue 3Y.
Yes.
My lord, I'm only pointing out 3I, my lord, concerns itself, my lord, only with, my lord, companies.
Yes.
Then, my lord, para 219. Sorry, my lord, 218 first. Thus, the order of the learned single judge is modified to the above extent. Liberty is given to APL and the parties to approach Testamentary court if need be and where there are serious doubts. Then, my lord, 219. Then, my lord, in view of inordinate so-and-so. Then, my lord, 220. My lord, fourth line, APO 92. That's Lodha's appeal. My lord, are disposed of in the light of above observations, modifying the impugned order to the extent as indicated above. And then, my lord, 221, in spite of the finding of, my lord, para 172,
Yes.
in spite of disposal of APO 92, my lord, GA4, my lord, GA3, my lord, 221, GA3 of 2020, GA4 of 2021, last paragraph, and GA5 are disposed of accordingly. So, my lord, the relief they asked for,
That has been disposed of.
yes, not granted.
Correct.
Correct. So, my lord, how, my lord, can somebody else now, my lord, come and, my lord, claim those reliefs here when Lodha himself failed? Now, my lord, kindly have a look at the Supreme Court order, my lord, from this.
Yes.
My lord, 424. My lord, of the,
So as per your submission, what they made a prayer that has been covered by this
yes,
division bench.
yes. My lord, it's been rejected, refused, in spite of para 172, because, my lord, they say we cannot give any direction to societies.
Okay.
The court cannot give any direction, so he couldn't have asked for that direction there. He needed to file a suit, which he hasn't done.
Yes.
Then, my lord, page 424, kindly see, my lord, the matter goes up on appeal. 22nd March, my lord, 425. My lord, we all appear. On naam ta achhe to. My lord, I find I appeared also, my lord. My lord, kindly see, my lord, for one matter, my lord, how much, my lord, income is being generated for us. My lord, kindly come to page 427, my lord.
It's good for the lawyers.
Good for the lawyers.
Yes.
Leave granted. Parties who have filed caveat take notice. We concur with the view taken by the division bench of the High Court in paragraph 2 and 19 of the impugned judgment. That's quick disposal of probate. We make it clear that at this stage, we are not granting any interim relief. So nobody's got any. If and they've also preferred, my lord, they are also there. If any direction relief is required to be applied for, the probate proceedings are pending before the testamentary court. Parties can apply in accordance with law. At this stage, there is no limited issue is required to be, and therefore, as per observations, that they decide that without paying any heed to the attempts made by the parties to sue. So, my lord, leave has been granted. Appeal now, my lord, is so everything's at large now, my lord, before the Supreme. Yes. Now, my lord, two other things happened. My lord, amongst, my lord, the appellants, my lord, kindly note, all the parties, there was no, my lord, society. Only one preferred. And that is, my lord, your lordship will find at page 113, my lord, of the compilation.
Yes.
My lord, admittedly, my lord, no society was there, my lord, before, my lord, the court. And the court also held that as a testamentary court, it could not give any directions to, my lord, society. So, my lord, the prayers naturally were, my lord, all, my lord, rejected. Page 113, my lord, kindly take. This was an order, my lord, dated 5th April 2022. There was only one society, my lord, which was before the division bench, my lord, which, my lord, went out. My lord, this is, my lord, my lord, in the cause title, my lord, here, my lord, one Mr. Pradeep Tandon had sought to represent one of the societies, my lord, who is, my lord, Shreyas Medical. My lord, that your lordship will find is a APO, my lord, page 116, my lord, Shreyas Medical Society.
GA1 of 2020.
My lord, 116, your lordships will find, my lord,
Yes.
Shreyas Medical Society, my lord, APO 96, right at the top.
Yes, yes, got it.
APO 96 with OCO so-and-so, so-and-so, my lord, has been filed. My lord, there were cross objections. So, my lord, then, my lord, kindly come to, my lord, page 119 where the order starts.
Yes.
My lord, there's a dispute as to representation because lordship will find Mr. Jishnu Shah, page 119, learned senior counsel appearing for applicant in GA2 in APOs 96, submitted that application his client has sought to substitute a new advocate in place. Affidavit has been served and copy of petition has been handed over. We file list APO so and so. The matter be deleted from the batch. So, my lord, this goes out. There's a dispute as to representation, whether that Pradeep Tandon, my lord, who in this case was appointed as trustee on 10th February, should, my lord, represent or not. My lord, Shreyas, my lord, Medical,
Yes.
which is another society. My lord, that.
Matter is deleted from the batch.
Yes. So, my lord, when the final judgment is delivered, my lord, 14 December, this appeal is not there.
Not on record.
Because no society, my lord, was before. That's what I want to, my lord, submit before your lordship. And this is recorded also, my lord, in para 221 at page 423, my lord. My lord, it's only, my lord, 92. Lordship will find APO 91 and 92. 96 does not feature, my lord.
A list APO 96 after 5 weeks.
Correct. And it gets detagged, my lord, removed from the batch. And the disposal, my lord, order. Here.
Yes.
My lord, it had been detagged, my lord, therefore, my lord.
Page
423, my lord, the disposal of the appeals, page para 220 and 221. My lord, do not deal with, my lord, APO 96. My lord, 220 goes up to 95, and then your lordship will find 98.
Yes.
And similarly, my lord, 221, it's only, my lord, 91 and 92.
Yes.
Because nothing about societies, my lord, was being, my lord, decided here.
Yes.
My lord, sorry.
Yes. Next.
My lord, could I? It's 1 minute to 3. My lord, I have another matter fixed at 3. My lord, could I?
You can.
May I have your lordships?
How much time further?
My lord, Monday your lordships given, my lord. They have, my lord, given me, my lord, so many cases to deal with.
But I'm appearing for the respondent number 3, my lord.
My lord, he has to make his presence felt.
Detax society.
My lord, I'm more or less appearing for the convict, my lord, who has not yet been convicted.
Whether you are from 2 to 258, you are in the chair or otherwise?
And I'm in the chair, my lord. I've had an operation in my teeth, my lord, so I could not make it.
My lord, may I have your lordship's leave? Monday it's fixed anyway.
So bring for the the counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. The matter is already fixed on 3rd of March 2025 at 2 p.m. Sorry, 2 p.m. Na?
2 p.m.
2 p.m.
Great.
I think because we had taken from your lordships 5 dates because we don't get dates otherwise. Your lordship is so burdened.
Next available dates are mid-April.
I've been told next available dates are mid-April with your lordships.
Mid-April, non-April.
Oh, April. Oh. Yesterday it was mid-April. Today.
Yes, sir. Yesterday, April, not after vacation.
Take your lordships.
हो गया क्या भी आया
Happy for the plaintiff, but
yes.
তুমি তো অ্যাফিডেভিট ইউজ করো না Milord was hearing my application, Milord. Milord, the defendant, my lord, has filed an application, my lord, section 8, Milord, seeking reference to the disputes, my lord, under the plaint filed by the under the subject matter of the suit, Milord, to international arbitration, because the disputes are covered by the arbitration agreement according to the defendant. Now, here the issue was my case is covered under section 45, group of companies. The plaintiff, my lord, admittedly not a signatory to the contract, but on last occasion, your lordship, my lord, I extensively placed all the communications happened between the parties, that includes plaintiff representative, it was apparent that the document was executed through the plaintiff number 1. Here is a sole plaintiff. In the objection, the plaintiffs did not dispute its relationship with the foreign company, with the parent company. The plaintiff in its objection also did not dispute the existence of the contract. Their objection was on the ground that the documents we have referred was not signed. This is an unsigned document. And though it was fallen from your lordship that since they are non-signatories to the contract, how the contract is binding upon them, that I am required to address to your lordship. My lord, in this regards, my lord, I have placed the email communications on last occasions. Now I will show just 2 or 3 paragraphs from their oppositions and 2 or 3 documents to demonstrate that the email IDs used by the plaintiff and the foreign companies are common. It is the common domain. They are still using the same domain. The communications will demonstrate that the parent's company instructing the plaintiff plaintiff to get the document signed from me. This is also quite apparent from the documents. And though the leave was sought by them on last occasion, because few documents I placed few correspondences in my reply, they sought a liberty to use an affidavit to such regard, but till date they have not filed it, and my learned friend is thinking that they will not use the affidavit. So the documents and the contentions made in my affidavit in reply, claiming that they are a part of group of companies and the Flint group of Netherlands, the company with whom I had a contract, who gave me a distributorship agreement, though the plaintiff is a non-signatory to the contract, it is binding on me, and the issue should be relegated to the arbitration reference. In this regard, my lord, kindly take the opposition once. And yes, opposition filed in GA 4.
Yes.
Yes. Lord, kindly come to page 4 of the opposition. Paragraph C. Paragraph C. It has been further alleged by the defendant that on or about 30th May 2020, the plaintiff had forwarded a distributorship agreement to the defendant, in response whereof the defendant protested and or objected certain terms and conditions of the said document. A perusal of the email dated 30th May 2020 would reveal that although the defendant had stated that the defendant is sending the purported agreement with signature, however, no such signed agreement was ever received by the plaintiff. So their case was that it was not signed. I have on last occasion, my lord, to recapitulate, I have shown to your lordship through my reply that the document was digitally signed by the parties, not once but twice. And in the communication, in fact, the contract was forwarded by the plaintiff itself. Now, my lord, the admission part is the next part. My lord, thereafter, I say, this is the positive statement made by the plaintiff. I say that the document relied upon by the defendant in the said application is not a concluded contract between the parties. Hence, the said application does not satisfy the mandatory provision of the Arbitration and Conciliation Act, so and so. Now, my lord, kindly come to page 5. My lord, I'm reading from the middle. It is hence evident. It is hence evident that the defendant has now woken up from slumber, and it's attempting to further evade the process of law by citing a document which is not admissible in law. So till now their aim is that this is an unsigned document and it cannot be accepted. Now, next paragraph, E. The malafide of the defendant would further evident from the fact that although the defendant resides and carries on business in Kolkata, but however, the defendant has insisted on a purported arbitration, which according to the defendant is to be held in Netherlands. Now, my lord, kindly come to paragraph 6, page 7.
Yes.
10th line of paragraph 6.
Yeah.
I deny that the distributorship agreement was executed between Flint, Netherlands and the defendant. So here, the plaintiff is otherwise accepting. Otherwise, he would not have denied. He would have simply said that whatever happened, it is between you and the Flint, Netherlands. I am no one to look into this, and I am no one, and I am not bound by those contracts. In fact, his objection is something else. He is in fact defending Flint, Netherlands, and saying that it was not, the agreement was not executed. Your Lordship, in the whole objection, there is not a single line where the plaintiff denies its relationship with the Flint, Netherlands, nor a Flint group of US company.
Correct.
He has also not denied the communications, the contents of the communications.
So if the agreement is not there, there is no signed agreement, how you can say the matter to be referred?
My lord,
denying.
My lord, I am for that reason, my lord, I am relying upon, my lord, may I refer section 45 of Arbitration Act, my lord, once. And my lord, this issue, my lord, has been, my lord, this issue, my lord, is no more res integra, my lord. The Supreme Court, my lord, in judgments of chloroform and other judgments, my lord, has said that by conduct of the parties, even a non-signatory, if it parts of the contract or by its conduct, even a non-signatory, my lord, is bound by the arbitration clause, my lord, the contract containing arbitration clause, my lord. My whole case is, my lord, the subject matter forms the claim forms subject matter of the suit, my lord, are arising out of a distributorship agreement.
Between whom?
Between the Flint, Netherlands, and the plaintiff is a part of a group of companies. May I show one document, my lord, from my reply? One document, my lord. I have on last occasion, I will not place the email communication. Only one document what the website of the Flint USA company states, my lord. There, the Indian company, plaintiff company, has been referred to that he will deal with the business of, he being an entity of a part of USA company, will do the business on his instruction. I have also annexed document in my reply obtained from a Ministry of Corporate Affairs demonstrating that the shareholding 80% share 80% shares owned by a Mauritius company, Flint Mauritius. That is also not disputed. My lord, kindly take the reply once. Brief. My lord, kindly take page 74.
Yes.
Yes. Kindly see the logo Flint Group, and I will show from their own document that they are using the same logo.
That, sir, the court has asked the simple question whether there is no contract established by you. How the court can refer the matter?
Yes.
Show me that. So if there is no contract, there is no. Show me that. You have shown so many things, email this, and he has acted on behalf of the different group, Norway and whatever it may be. Show me the agreement entered between the parties wherein the plaintiff has signed or plaintiff is the party to this agreement.
No, plaintiff has not signed.
Then?
Plaintiff has not signed.
Then?
Plaintiff has not signed. This is an admitted position.
If there is
And
no sign,
I have not claimed that he has signed the contract.
So how the, if it's not a signatory to the agreement, how the clause can be say
My
that
lord,
it-
may I refer section 45?
Yes.
Once, my lord. Power of judicial authority to refer parties to arbitration.
Yes.
Notwithstanding anything contained in part 1 or in the Code of Civil Procedure, a judicial authority, when seized of an action in a matter in respect of which the parties have made an agreement referred to in section 44, shall, at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration. So, my lord, here the words mentioned, or any person claiming through or under him, refer the parties to arbitration. So I'm relying on this phrase that the any person here, this as per the section of 45, any person could be anyone, even a non-signatory.
Yes.
If he is a part of the transaction. My humble submission is this. In my case, the plaintiff had played a role of selling affiliate for supply of goods of Flint, Netherlands to me. Now, my lord, in this regard, my lord, since my lord, I will just.
Is there an agreement with you and the Flint,
Flint, Netherlands, my lord.
Netherlands?
Yes.
Have?
Yes.
Have you invoked any provision, invoke the arbitration clause in that?
No, I have not yet.
Then?
I have not yet.
So if you're telling that you are having the agreement with the Netherlands,
yes,
and in that case you have signed you are the party to the agreement, and Netherlands party is are the party to the agreement. In that agreement there is a clause of arbitration, and you are telling that that clause of arbitration is to be imposed upon this plaintiff,
yes.
who had worked as an agent, as a whatever it is, as a commission agent, whatever it is. But you have not invoked the provision of section of the arbitration clause of the main person who has entered into an agreement.
My lord, but my lord, here the issue is, my lord,
And
even
you also not filed you also not filed an application here for impleading that party as a defendant in the suit. You have not filed any application here. For the last 3 days, you are arguing the matter. This email, that email, that was, but you have not. An agreement is with the third party. In the third party agreement, there is arbitration clause. He is the agent of that third party, and you are telling that he should 45 is to be invoked against the plaintiff, but you are not invoked this arbitration clause against the first party, who is the party to the agreement.
my lord, I bow down to your lordship, my lord. Your lordship is correctly observed, my lord. But my humble submission is, my lord.
Have you issued notice under 21 to the that party, who is the party to the agreement, for appointment of arbitrator?
No, my lord. Till date, not.
Then
Till date.
Then how the 45 been invoked against him?
But my lord, my humble submission, my lord, I will try to satisfy your lordship, my lord. So far, in connection of section 8, my lord, what I am supposed to show, only for the purpose of referring the disputes to the arbitration.
See, referring the dispute to the court, as per the judgment of the Supreme Court, as per that, this court is binding. If the court satisfied, they are the party to the agreement. There is an arbitration clause. We cannot keep the suit pending in the court. It has to be referred. Then all the points is to be adjudicated by the arbitrator under section 17, if any disputes arose. But the person who wanted to send them refer the parties to the arbitration, the person has to satisfy this court. Yes, this clause is applicable to this party, so that's why the suit cannot lie before this court. And your main agreement, admittedly, there is no agreement with the plaintiff and you. You have relied upon the communication between the plaintiff and you. Your case is that plaintiff is the agent or whatever it may, or attorney representative of the main party. And there is an agreement with the main party. In that agreement, there is arbitration clause.
Yes.
And you have not invoked the provision of arbitration clause against the main party, who is the party to the arbitration, who is party to the agreement, in which the arbitration clause is there. So how this court can, and you have not made any application before this court for making that party as a party defendant.
My lord, in that event, my lord, I will rely upon one judgment, my lord. My lord, yes, my lord. In that event, my lord, here the situation was, my lord, identical.
Show me. That is the only question here.
Yes.
To satisfy this court.
Yes. My lord, I'm relying, my lord. Judgment citation 2018 SCC online. Madras 13299. 2018 SCC online.
CC
Madras
online. Madras
13299.
299.
299. Yes.
Yes.
Let me please. Lord, here, my lord, the situation was more or less identical to my case. My lord, here suit was filed by the plaintiff, my lord, an application was filed by the defendant seeking reference to the disputes. Here the issue was also that the plaintiff was a non-signatory to the contract. Lord, kindly come to paragraph 9 of the authority. The appellants are functioning from the same office. All the group of companies belonging to the Sun Edison correspond through the same email ID. The respondent number 2, as per the undertaking, appointed the appellant number 1 as its agent to receive an acknowledgement.
Yes, then he is the party or the suit. Appellant number 1, appellant number 2, both the parties are both are the parties before the court. That's why I'm asking you.
My lord, appellant here is, my lord, was aggrieved by the order of the dismissal of the suit.
The appellant are functioning from the same office.
Yes.
All of the group of the companies belonging to the Sun Edison
Yes.
correspond through the same email ID. The respondent number 2, as per the undertaking, appointed by the appellant number 1. So who was the respondent number 1?
My lord, the respondent number 1, my lord.
Who are in that case?
My lord, the appellants here, my lord, are the plaintiffs.
The
appellants here are the plaintiffs. The respondent number 1, my lord. My lord, may I please the, my lord, the appellants are functioning from the same office. All the group of companies belonging to the Sun Edison correspond through the same email ID. The respondent number 2, as per the undertaking, appointed the appellant number 1 as its agent to receive and acknowledge any notice by way of writ in connection with the undertaking. The undertaking also concerns its obligation as binding upon its successor and permitted assigns. It was also agreed that neither the respondent number 2 nor the appellant number 1 shall assign or transfer any interest or rights, benefits, etc. under the undertaking without prior written consent of the respondent number 1. Now, paragraph 10. The undertaking contains an arbitration agreement. It is governed by the International Chamber of so and so. Now, my lord, the paragraph 10, my lord, is only now, my lord, kindly come to paragraph 11. Contrary to the undertaking, the shares were sold by the respondent number 2. Thus, the respondent number 1 invoked the arbitration clause when notices were issued in terms of clause 9 of the undertaking. It was received by the appellants inter alia contending that they are not parties to the undertaking. Not stopping with that, the appellants approached the court, filed CS number 502/2007 and 12 of 2018, seeking the following reliefs. Now, paragraph 13. The respondent number 1 filed application so and so, seeking to revoke the leave granted under so and so, to reject the plaints and to refer the parties to arbitration. The learned judge, by a common order, allowed the applications filed by the respondent and thus dismissed that the appellants. Dismissed that of the appellants. Agreed by the present original side appeals are filed before us. Now, submissions were recorded. Lord, kindly come to just to how the case was identical to my case, my lord.
Yes, sure.
May I refer paragraph 20?
Yes.
Though it was submission, but it was identical to the facts of my case.
Show me.
Yes, the learned senior counsel appearing for the respondent would submit that the appellants and the respondent are parts of the same entity, having common central control. Their email ID domain name is the same. The appellants have their offices in the same building of the paid up share cap. 99% of the paid up share capital of the appellant number 1 was held with so and so. Respondent number 2, the appellants were the subsidiary of so and so. all of them representative as the common business venture at the time of execution of the undertaking.
Yes.
The contractor,
Common venture undertaking.
yes. My lord, I will show from the correspondences, my lord, the
And both are party before the court. Respond number 1, respond number 2. Both are party before the court. See what happens. You here the plaintiff has filed the case against you.
Yes.
Admittedly or deny whatever it may be, it is your case. As from the case, he is a recovery of money. Correct? You are not paid the amount, supplied goods. You are telling that that supply goods with regard to you entered into an agreement with the Netherlands part. Correct. And he is the agent or he is the subsidiary, whatever it may be. And he has filed an application for recovery. He cannot file an application for recovery because there is an arbitration agreement between you. And he is the intermediary of the
parent company.
And parent person, company.
Yes.
So that's why he should.
Yes.
So he has not made the party to the parent company. Correct. From where he born. From where he born. And you are taking the plea that yes, he is the intermediary party of the main contract. So the matter is to be referred. Suppose this court will refer the matter to the arbitration. What the arbitrator will decide? If the main contractor is not in the party, not referred to the arbitration.
The arbitrator will decide the claim.
Which document? If the main person is not there.
Well, obviously, my lord, in arbitration, my lord, the main
Think of it, sir. Think of it again. I am indicating you. Think of it. Here, I admit, law settled, but the party should be before the court. Party should be before the court. If the main party would be before this court, and you are relying upon that, then the submission of the other party is matter in the case. What stand they will take? He is the intermediary or he is not? He is not entitled to get the amount because they have this amount, the material is not of that company. Then?
My lord, I thought, my lord, earlier, but it didn't strike. I thought of addition of party, but
not addition. If suppose this court grant on basis of this court allow your application, what the arbitrator will do? On the very first day, he will file an application under 17.
16.
Sorry, 16. Then, what defense you will take before the arbitrator? Because he will say, I am the third party. Your submission reminded me my initial day of the practice. When arbitration case was given to me to deal by the administration. Then it was in Delhi. Then I went. I find the same thing. Then first I filed an application for addition of party on the way of the CPC. Then subsequently evening I realized it is not. Think of it. Take advice. What is to be done?
Incidentally, my lord, yesterday I was in Port Blair. My lord, it's too hot there.
Huh?
Weather is too hot there. I came today morning.
Okay. Think of it.
Yes, my lord.
Think of it. What the law is correct. Even Mr. Banerjee is there. I have passed an order in his case.
Descon matter.
He has argued. In that case, documents were there.
The CCC didn't have my party's name.
Ah.
I had a separate agreement. My agreement didn't have the arbitration.
Yes. Not having an arbitration cause, but there is a communication. He has filed that.
It is true what has fallen from your lordship, that there will be a difficult. And it's only referring.
Referring.
After that, parties will have to take steps for appointment.
So what will do? What will be the effect of the order of this court if this court will refer? Because the main party is not there.
Dasgupta is enjoying your lordship's full support.
So he is in the.
Dasgupta is very confident of his matter.
Everybody.
He's in cycle.
We have been told if the judges in your not say anything.
Keep
That is what I do.
Because many of the judges earlier, the senior judges, when we used not
You, my lord, in the bench, my lord.
sensations appearing for the plaintiff, sensations appearing for the defendant. The defendant has filed an application being GA4 of GA-Com 4 of 2024, praying for referring the parties to the arbitration. Full list of counsel for the defendant, prays for time for taking. Prays for time. According case is adjourned. Let the matter appear. हाँ let ना एक ऐसी डेट तो लेट दी क्या करता हूँ देख let the matter appear on the commercial ना
Yes, my lord. This is a commercial.
18th March.
If they wanted to, I'm so sorry, my lord, I'll add. But if they wanted to resume their argument, my lord, on the next day, if they are advised so, my lordship may fix a date for that.
I will take appropriate instruction, my lord.
Otherwise, it will go to May, my lord, as it is happening.
I will take necessary instruction, my lord.
Okay, on that day, that I will fix that.
Because my lord, today I understood 19th March slot is open. My lord, that has opened
No, no,
because
you are enjoying
one
the-
matter was adjourned. My lord, Mr. Arindam Banerjee was appearing in one of the matters. It was fixed on 19th March, which
Lord, he is enjoying the interim order, my lord. Already.
I need a decree.
19 March at
Interim order will not do.
19
Yes.
March at 2 p.m. करना.
Grateful, my lord, grateful.
Grateful.